Magandang hapon po mga igan, matapos sa mahigit isang buwang pahinga, magsisimula na sa ilang sandali ang pagbabalik ng impeachment trial ni Chief Justice Renato Corona.
Samahan niyo muli kami sa special coverage ng GMA News TV sa makasaysayang paglilitis sa punong maestrado ng Korte Suprema. Ako po si Vicky Morales.
Ako naman, Arnold Glavio.
At ito po ang The Chief Justice on Trial.
Patuloy po tayong magbabantay sa mga pinakamainit na pangyayari dyan po sa Senado.
At mag-uulat mula roon ang ating kasamang si Joseph Moron.
At dahil hindi po kami bumibitiw sa paghahatid ng pinaka-komprehensibong coverage kaugnay sa impeachment trial ni Chief Justice Corona, makakasama po natin muli ngayong hapon ang isa sa pinaka-malalaking pangalan po sa larangan ng abogasya sa bansa.
Yan po ay wala pong iba kundi si Dean Raul Pangalangan, dating dekano ng UP College of Law. Magandang hapon po, Dean, and welcome back.
Hello, thank you for inviting me.
Ayan, pero bago natin simulan ng diskusyon, Dean, puntahan muna natin si Joseph Morong sa Senado. Mukhang may caucus yata yung mga senador. Ano ba inaasahan ngayon dyan sa resumption ng impeachment trial? Go, Joseph!
Okay. Welcome back muna sa inyong dalawa.
Welcome back.
Day 35 tayo ngayon. Nagpahinga for a month yung Senate Impeachment Court. But ngayong araw na to ay babalik itong si dating Manila Mayor Lito Atienza for cross-examination. Si Atienza ay nag-testify tungkol dun sa pagbili ng Manila City Government doon sa ari-arian ng Basagirote Enterprises for 34.1 million. So babalik siya. Panahon naman ngayon ng prosecution to cross-examine him. Tapos matatandaan, nung bago nag-break tayo, ay nagkabangga itong si Lead Defense Counsel Attorney Serafin Cuevas at si Senador Ralph Recto tungkol doon sa nature ba noong 34.1 million. Ang sinasabi ng defense is that this is money that belongs to Basagirote Enterprises but interest lamang sa isang account itong si Chief Justice. Ang sinasabi ng prosecution ay dapat nakareflect ito sa salin. So doon sila nagbangga at that time. Kaya sa caucus iga no, ng mga senador kanina ay maraming motion at tinalakay. No? Kasama dyan yung mga motion to quash yata doon sa petition ng defense to ask si DOJ Secretary Leila de Lima to testify. And then kasama rin dyan, ito, handa na ba kayo? Extension ng trial hours. Ayon dito kay Senate Presiding Officer Enrile, ay kung siya lang na daw, kaya niya kahit hanggang alas 12 ng hating gabi. Sabi nitong si Senate Majority Floor Leader Tito Soto, ay tingnan natin kung hanggang kaya hanggang mga during dinner time or right after dinner time, mga 9 o'clock. So we will know kung ano yung magiging desisyon ng Senate tungkol dyan. Ang gusto kasi nila, Igan, Vicky, ay tapusan before the Sinide adjournment of Congress on June 7. Narito ang pahayag ni Senador Soto.
Hopefully, in the last week of May.
Pero ang sabi ng defense, parang kaya kahit na by July, pagtapos ng SONA, possible pa rin yun.
Huwag naman gano'n. Sobra na yung, di ba? Tatlong article na lang ang pinag-uusapan Tapos isang article nandun ang medyo matiin ng usapan So, kayang-kaya na nila yun.
Family picture. Igan, Vicky, kasama natin sa puntong ito ang abogado ng magkabilang panig, si Attorney Karen Jimeno ng Defense at saka si Representative Miro Kimbo. Welcome back sa inyong dalawa at ladies first.
Of course,
absolutely. Ma'am, may motion yata, may mga inclinations ng Senate to extend yung ating trial hours.
Sa amin naman, okay lang na ma-extend kung mapabilis yung paglilitis. Pero siguro, dapat maging practical din tayo. Ang aming lead counsel ay may edad na rin. Sa palagay namin, magiging mahirap din para sa kanya at for the rest of the defense team kung ganun kahaba. Can you imagine kung 8 hours, ibig sabihin, ganun din kadami yung kailangan namin iharap na testigo. At hindi madaling magpresenta. Kahit sino abogado masasabi sa'yo na kahit isang hearing nga lang, pagod na pagod sila para paghandaan ito the next day. So what more for trial hours na tuloy-tuloy from 2 to 10 p.m.?
Yun muna. Kayo, sir. Payag kayo doon?
Well, payag kami, no? I think pagpapakita ito ng Senado na determined talaga silang tapusin ito sa lalong madaling panahon. Pero siyempre, malinaw sa amin na dapat wag rin natin pagkaitan ng depensa ng oportunidad ng tamang panahon para makapag-present ng evidence. But judging from their statements as well as the list of witnesses that they presented before, ay sa tingin namin hindi na ito aabot ng matagal na panahon. We should be able to wrap it up by at most by the end of May. Siguro maganda upuan ng mga parties, upuan nito para makapag-agree kami sa isang specific schedule.
Attorney Jimeno, ilan pa po ba yung mga witnesses natin na ipipresent?
Siguro mga nasa 12, mga medyo higit sa 10. Pero konti na lang, mga higit kumulang 10. 12 ang tingin namin.
Tansya nyo, makakailan tayo sa isang araw?
Depende rin kasi dati, halimbawa na lang, nung bago mag-trial break, nung nakaupo dun si Mayor Atienza, meron mga 10 witnesses nakaupo sa holding room. Dahil yun yung mga nag-aantay na naipon each day.
Okay.
Dahil minsan may hindi kami naasahan na tatagal pala yung pagtatanong ng senator judges. So, sa paligay namin, kung hindi matagal yung pagtatanong, yung normal na pace ng trial, kaya matapos baka in 2 weeks.
So probably no need to extend?
Sa tingin naman namin, hindi.
Ma'am, dun ba sa 12 kasama si Chief Justice or kahit si Mrs. Corona?
Siguro tignan nila. Kasi tinitignan pa talaga namin kung saan siya kailanganin. So, inuuna muna yung ibang testigo.
He did say before na parang he will explain in due time. Is it in the Senate or outside?
Siguro ito yung isang tanong na para sa kanya, no? Kasi kung impeachment ang pag-uusapan, syempre, ang in due time dapat sa loob ng impeachment court. But I guess it depends on the issue rin.
Okay.
Ito ba isang issue na kasama sa impeachment complaint or na lumutang na lamang pero wala dun sa loob ng impeachment complaint at kailangan niya pa rin sagutin?
Your position, of course, you want the CJ to testify?
Well, it's not up for us. I think it's unfair for us to impose defense kung ano yung dapat nilang gawin. Mas alam nila yung nararapat. Pero sa tingin namin, ito'y hinihiling ng mga senador at sa tingin namin, base sa ebidensyang present nila so far, na si Chief Justice lamang ang talagang makakapagbigay o mapapabulaanan yung lahat ng proof or evidence na aming naipresenta. I think it will be very difficult to convince the senators to vote on an acquittal if the Chief Justice does not show up. Yung sala niya, personally prepared by him, under oath niya, siya lang mismo ang makakapagpaliwanag sa iba't ibang aspeto doon. Hindi yung maaaring magawa ng ibang bagay. Peripherally, indirectly, pwede, pero in the end of the day, siya lamang ang makakapag-testify to that. Yun ang position po namin.
Attorney Meno, medyo uminit yung issue ng $10 million daw. Meron daw si CJ na yun. Number 1, meron ba?
Well, isa ito sa bagay na tinanong na rin namin sa kanya. And nagbigay siya ng official statement noon sa media na hindi raw totoo. So he flatly denies na merong $10 million na nag-exist, wala daw, at wala daw siyang ganitong halagang pera.
Do you know for certain? Or well, I know that this is a petition before the ombudsman, no? Kaya
Hindi
lumabas
namin
na.
alam. Wala kaming idea. We have not seen the order of the ombudsman. We have not seen the base for that investigation. So at this point in time, we have no idea. But we're very much interested to find out. And if we find out that there is sufficient basis to present this as evidence, we will certainly present it. Because we made a specific reservation on foreign currency deposit accounts
Ba't
when
hindi
we
niyo alam?
arrested. Hindi pa eh. Because the investigations of the ombudsman are confidential by law.
Okay.
So hindi pa namin alam kung ano talaga. In fact, what you know is just the same as what we know is what we read in the newspapers.
Okay, Igan, Vicky, if you have questions for both of them.
Siguro, Joseph, pwede natin talungin sina Miro at Karen kung ano kaya ang naging epekto nitong long break sa kanilang mga panig. Pabor ba sa kanila o hindi?
Effect daw ng long break.
At para sa amin, mahirap sabihin kasi meron mga lumabas na surveys during the break na hindi pabor kay Chief Justice Corona. Pero pag tinignan nyo naman yung period kung kailan sinagawa itong surveys, mga around March 10 to 13. Nung panahon na yon, 2 araw pa lang na nakapagpresenta ng ebidensya yung defense. So hindi natin masasabi na hindi pabor sa defense yung long break because during that time wala rin naman nangyari. And hindi pa naririnig yung buong storya ng side naman ni Chief Justice Corona.
Miro, did you guys did more research? Did you do more research?
Well, it allowed us to at least have a more distant perspective, mas malayo para mas nakita namin saan papunta. Pero nakabuti ito tingin ko para sa amin as a team kasi mas nakita namin yung mga dapat namin gawin at makikita natin yung mga pagbabago over the next few days or 2 weeks, 3 weeks while the defense makes its presentation.
Okay.
Joseph, magiging relevant pa kaya sa kanila itong bagong SAL-N na final ni Chief Justice Renato Corona?
Okay, there's a new SAL-N, yung 2011, i-final ng April 13, no? At kung tama yung pagkakarinig ko kanina kay Attorney Esquerra is that there are certain, corrections or maybe fine-tuning in the SAL-N of 2011 of the Chief Justice. Are you at liberty to say kung ano yung mga corrections? Or surprised to? Kasi sabi, lalabas daw to at the end, towards the end of the trial, na parang this will be the key documents.
Personally, Joseph, I can't give a definite comment doon sa mga corrections niya kasi hindi ko pa ito nakikita dahil sa amin at issue right now would be lahat ng SALNs ni Chief Justice Corona nung nakaraan. Yun yung pinaglilitisan natin. But I guess at the end of the day, baka to prove a point na in good faith maybe yung mga ibang pinagtatalunan katulad nung for instance yung Bellagio kung kailan ba dapat to talaga i-declare or yun nga issue na assess value, market value, tapos acquisition cost na hindi nilagay. Baka naman doon, linagay na. Ang alam kasi namin, nung finil up ni Chief Justice Corona itong 2011 SALN, hindi niya kami kinonsulta, hindi niya kinonsulta yung defense team. But then, baka naman by now, pinag-usapan niya na with yung mga lawyers na assigned doon sa Article 2.
What do you think of this, that the CJ maybe made some changes?
It's relevant in a sense that doon natin makikita kung may pagbabago, then in a sense it's also an admission of some erroneous or some mistake or some wrongdoing in a sense. No? But I think it's premature until we have actually seen the 2011 SALN.
Okay. Igan, Vicky, narinig na natin yung all rise. So,
Okay?
Alright, maraming salamat sa iyo, Joseph Morong, Akit Karen, and Miro. Thank you very much.
Thank you very much.
At sa huling araw, bagong Holy Week, break, nakita natin yung iba sa mga issues dyan. Isa na rito, yung biglang paglitaw nga ng ombudsman. No? Mamaya tanungin natin sa ating panauhin kung dapat ba maging parallel yan. Samantala, nagsisimula na po impeachment proceedings. Panoorin po natin ito.
We are rolling. The continuation of the impeachment trial of the Honorable Chief Justice of the Supreme Court, Renato C. Corona, is hereby called to order, and we shall be led in prayer by Senator Lauren Legarda.
Panginoong may kapangyarihan, kami sumasamo sa inyo na may kababaang loob upang mabiyayaan ng karunungan, pag-unawa at lakas ngayon at sa mga darating na araw. Lubos kami nagpapasalamat sa inyong paggabay sa aming pagdinig sa kaso ng punong maestrado. Panginoon, inaalay namin sa inyo ang panahon na aming ginugugol sa pagganap ng aming tungkulin. Basbasan niyo po kami ng kaliwanagan ng isipan upang sa huli ay maibigay namin ang patas at nararapat na kapasyahan. Amen.
The Secretary will now please call the roll of senators.
The Honorable Senator Judges Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President. Ilan?
With 16 senators, judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the March 22, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the March 22nd, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Majority Floor, the Secretary will please call the case.
Case number
as an impeachment court.
00220011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances. Majority Floor Leader.
May we ask the respective counsels to enter their appearances for the prosecution?
Good afternoon, Mr. President and honorable members of the Senate. For the House of Representatives Prosecution Panel, same appearance. We are ready, Your Honor.
Noted. The defense.
For the defense, Your Honor, the same appearance.
Noted.
We are ready, Your Honor.
Noted. Majority Floor Leader.
Mr. President, before the business for the day, there were three motions that were decided on by the caucus. So may I be allowed, with the permission of the court?
Yes. What are the motions?
Yes, the first one is a letter of DOJ Secretary De Lima and reply of the Senate. In her letter to the Senate President dated March 22, 2012, DOJ Secretary Laila De Lima conveyed her apology for her failure to comply with the subpoena issued by the court, which directed her to testify and bring certain documents before the court last March 22. Secretary De Lima added that while she is willing to appear before the court, she also requested that her further appearance be dispensed with, since the matters on which she is being asked to testify on by the defense have already been covered by her direct testimony when she appeared as witness for the prosecution, or that such matters should have been brought up by the defense during their cross-examination of her. Acting on her request for discharge, the presiding officer, in a letter dated March 27, 2012, informed Secretary De Lima that in the interest of justice and fair play, counsel for Chief Justice Corona should be similarly afforded the opportunity to raise direct examination questions in defense of their client, just as the House panel of prosecutors were afforded the same opportunity to propound direct examinations questions to her. On May 4, 2012, the prosecution filed a motion to quash the subpoena, contending that the defense has been previously afforded the chance to cross-examine Secretary De Lima and to their questions for 2 days. The prosecution also claims that to recall Secretary De Lima will be violative of her rights and would be unfair to the prosecution and the court, as it will unduly lengthen the proceedings. With that, Mr. President, and as agreed in the caucus, I move that the presiding officer rule on the matter.
The subpoena requested by the defense is based on their notion that they want to present the Secretary of Justice as their own witness. Although she was presented by the prosecution and she was subjected to a cross-examination, the appearance of the Secretary of Justice then was not at the behest of the defense. And so therefore, given the fact that the respondent is entitled to compulsory process to set up his defense, the motion is denied. The motion to quash is denied. And the defense is directed to confer with the Secretary of Justice so that you can determine the date and time when she will have to be asked to appear in this court to be presented as a witness for the defense. So ordered. Next, we have a motion.
Yes, Mr. President, the court also is in receipt of a manifestation and request filed on April 24, 2012 by spouses Rodel and Amelia Rivera. A subpoena ad testificandum et duces tecum was earlier issued by the court upon the request of the defense, commanding Mr. and Mrs. Rivera to appear and testify on March 20, 2012, and every day thereafter until discharged. The spouses Rivera requested that they be excused from attending the hearings from May 5 to May 27 in view of their trip to the United States, which had been scheduled long before they received the subpoena. The Riveras further manifested that they are ready to attend the hearings and comply with the subpoena after they have returned from their trip. Mr. President, we have been previously informed that the defense is willing to forego with their testimony.
Can the defense please confirm this for the record?
If they will not, if Your Honor, please, if they will not be available by the time granted by this honorable court, we may dispense with their testimony and present somebody else who will testify on the same subject matter. For instance, Your Honor, we have in mind introducing the broker who effected the sale between the Coronas and these witnesses, Your Honor.
All right, the manifestation of the Chief Defense Counsel is noted.
Thank you, Your Honor.
Next
Mr. President.
motion.
Yes, finally, Mr. President, on March 16, 2012, Counsel for Chief Justice Corona asked that this court issue a subpoena ad testificandum et duces tecum to Malu Mangahas, Carol Ann Ilagan, and the cameraman, men, crew, all of the PCIJ, for them to testify and bring copies of the SAL-Ns and all other documents, letters, and requests related or pertinent to the various news reports posted in the PCIJ website. The defense submits that the testimony and documents asked is for the purpose of disproving any alleged willful omission of the entries in the Chief Justice's SAL-Ns and to show good faith in filling up the same. The prosecution on March 19, 2012, filed its opposition to the request on the ground that the testimonies and documents sought are patently irrelevant. On March 21, 2012, Malu Mangahas, Carol Ann Ilagan, and Ed Lingao, by counsel, filed their opposition, praying that the request for subpoena be denied on the ground that the requested testimonies, documents, and videos are irrelevant and inadmissible, and that the request itself is unreasonable and oppressive. I move to submit this matter for the consideration of the presiding officer, Mr. President.
The chair would like to request the defense panel to explain to the court.
If Your Honor, please.
What are the documents sought to be produced by the persons representing PCIJ as in this court? And then second, what's the relevance of these documents?
If Your Honor, please.
For the defense of the respondent.
With the kind permission of this Honorable Court, Your Honor, the defense would like to announce for the record that we have foregone any attempt towards having these witnesses compelled to appear pursuant to a subpoena to be issued by this Honorable Court, together with our request with subpoena duces tecum, Your Honor. After an examination of our position and relevant matters in our possession, we have finally arrived at the conclusion that we may dispense with the testimony.
So you are withdrawing your request?
Right, Your Honor.
Right.
Thank you very much, Your Honor.
This court notes the withdrawal of the subpoena duces tecum et testificandum addressed to the members of the PCIJ.
Thank you. Yes.
Majority Floor Leader.
Yes, Mr. President, before the continuation of the presentation of evidence by the defense, may we recognize Senator Miriam Defensor Santiago?
The gentle lady from Iloilo has the floor.
Mr. President, I ask no question of the parties or of counsel or of any witness proposed for presentation this afternoon. Instead, I would like to make a manifestation, particularly read for the record my memorandum of authorities on two questions that I believe to be crucial to this stage of our impeachment proceedings. The first crucial question is, does this court have authority to order or otherwise compel the parties to finish the trial such that this court might be able to promulgate judgment on or before June 7 when the Congress adjourns? And the second question is it relevant for this court to receive evidence on the alleged irregularities that attended the sale by Cristina Corona, acting for a family corporation, to the City of Manila? Let me go to the first point. Has this court the power and authority to order the parties to end the trial on or before June 7, the scheduled end of the Congress session? My humble answer is yes, this court possesses that power. Here are the authorities. Under the rules of court, Rule 133, Section 6, the court has power to stop further evidence on a particular point, quote, when the evidence is already so full that some witnesses to the same point cannot be reasonably expected to be additionally persuasive, but this power should be exercised with caution, unquote. Further, under Rule 119, Section 11, Paragraph C, quote, the prosecution and the defense may, in that order, present rebuttal and non-rebuttal and sur-rebuttal evidence unless the court, in the furtherance of justice, permits them to present additional evidence bearing upon the main issue, unquote. In People v. Tan, decided by the Supreme Court in 1999, the High Court ruled it is within the sound discretion of a trial judge to allow a party that has rested its case to introduce rebuttal evidence. Further, under the Rules of Court, Rule 135, Section 1, quote, justice shall be impartially administered without unnecessary delay, unquote. Under Section 5, entitled Inherent Powers of Courts, quote, every court shall have power, letter D, to control in furtherance of justice the conduct of its ministerial officers and of all other persons in any manner connected with a case before it in every manner appertaining thereto. Parenthetically, in the President Clinton impeachment case, the U.S. House of Representatives impeached him for perjury and obstruction of justice on 19 December 1998. The Senate trial began on 7 January 1999. He was acquitted on 12 February 1999, or a little over only a month. Therefore, I humbly submit that this impeachment court, after nearly 5 months, contrast this with the 1-month trial of President Clinton. After nearly 5 months, this court possesses authority to order the conclusion of trial on or before June 7, so as to allow judgment to be promulgated before Congress ends this session. Let me now move on to point number 2. Is it relevant to the impeachment proceedings that the sale to the City of Manila of land owned by Basa Guidote Enterprises Incorporated, represented by Cristina Corona, was disallowed in audit by the Commission on Audit following this timeline? In 2001, the negotiated sale was consummated. The city government took possession of the property and constructed a public market on it. Ms. Corona received a check worth some $35 million, allegedly in trust for BGEI. She deposited the check in her own account. 2002, 1 year later, COA issued a notice of suspension of payment. It appears that the City of Manila took no action because of alleged failure to serve the notice properly. Hence, under the State Audit Code, the transaction remained an unsettled account. The notice of suspension was based on alleged failure to submit certain documents, that is, the original copy of the deed of absolute sale, the TCT in favor of the City of Manila, the recommendation of the appraisal committee, and copy of the latest tax declaration transferred from the owner to the City of Manila. And then, after these developments, in 2001 and then in 2002, in March 2012, or after 11 years, COA issued a notice of disallowance. In Carabello versus Court of Appeals, decided by the Supreme Court in 2009, the court ruled that the term unexplained matter normally results from non-disclosure or concealment of vital facts. It appears that the Corona Sang did not conceal the vital fact of the sale. In his 2003 Sang, Corona mentioned the item, quote, cash advance from BGEI, parenthesis, Wife's Family Corporation, parenthesis, of 11 million pesos, unquote. The Corona Sangs do not include the purchase price of 35 million because Cristina Corona apparently received it from the City of Manila in trust for the corporation. The 1994 Sang form did not require the declaration of trust arrangements. Subsequently, the 2006 to 2007 Sang manual required the declaration of assets held in trust, but the Civil Service Commission has deferred the application of this manual. Remember, our basic issue here is it relevant to deal with alleged irregularities in the sale of land? In law, the term relevant means logically connected and tending to prove or disprove the matter in issue. It means having appreciable probative value, that is, rationally tending to persuade people of the probability or improbability of some alleged fact. The word relevant means that the COA notice of disallowance and the failure to include the purchase price of corporation property in the Corona SAL should be so related to each other that one fact tends to prove the other fact. Under this definition, the COA notice of disallowance is irrelevant to these impeachment proceedings. Under the Rules of Court, Rule 128, Section 4, entitled Relevancy of Evidence, quote, evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue, unquote. In the case of DePaul v. NLRC, decided in 1999, the Supreme Court ruled, quote, a party alleging a critical fact must support its allegation with substantial evidence, and any decision based on unsubstantial allegation cannot stand as it will offend due process, unquote. Therefore, applying the test of relevancy and under the principle of criminal due process, I humbly submit that any evidence tending to prove any irregularity in the sale of BGEI property to the City of Manila would be irrelevant to impeachment proceedings over the alleged omissions in the SAL of the defendant. Evidence on alleged irregularities should be presented to the Solicitor General for litigation in court. I humbly make these submissions to our colleagues in the impeachment court. Thank you.
Thank you. Noted. Majority Floor Leader.
Yes, Mr. President. In our last hearing, the prosecution has asked for the continuance in their cross-examination of former Manila Mayor Lito Atienza. May we inquire from the defense if they are ready to present Mayor Atienza for the continuation of the cross-examination?
We are, Your Honor. We will call him to the stand for continuation of the cross-examination by the prosecution, Your Honor.
Then proceed.
May we request for a minute, Your Honor? We'll call him.
By the way, what is the fact sought to be proven by the presence of the former mayor of the City of Manila here?
If Your Honor, please.
Yes.
The cross-examination had already gone to the extent of narrating in details the alleged circumstances surrounding the acquisition by the City of Manila of these properties and the payment, therefore, in the amount of 34.7 million pesos, Your Honor.
Only to the extent that there was a payment of 34.7 million pesos.
Your Honor, we introduced evidence to that effect in order to show how Chief Justice Corona was able to acquire allegedly some properties which do not seem to be justified by his reported income.
So, in effect, given the statement of the lady from Iloilo, nonetheless, the position of the defense is that the transaction is relevant, the transaction between Manila and the Basa Guidote Corporation is relevant to this case to the extent of the proceeds of the sale, which will now be treated as a part of the funds used by the Chief Justice to acquire properties. That it?
That is correct, Your Honor.
All right, proceed.
Sana. Din, pinusundo na? Ha? Pinusundo na? May we request the indulgence of the court for only 1 minute.
All right, 1 minute suspension.
Okay, agad ko lang tanongin si Dean Pangalangan, no? Doon sa issue ng ombudsman,
Yes.
bago po nagsimula itong ating impeachment, gusto ni ombudsman na papaliwanagin itong si Chief Justice sa $10 million na bank account. Paano maapektuhan yung impeachment trial na ito?
Okay. The starting point is that the prosecution tried to get to look into this question, the dollar accounts, in the impeachment trial.
Opo.
Naharang sila.
Opo.
The Senate ruled on the confidentiality of the the dollar accounts. Inakyat yan sa Supreme Court. The
Opo.
Supreme Court similarly protected the confidentiality. So, hindi natuloy doon sa impeachment trial. So, this is another tack, another angle at which by which to secure the evidence through the ombudsman. So there was a complaint filed before the ombudsman. Now, Arnold, this is an old debate in law, whether the ombudsman can inquire into can investigate impeachable officers.
Okay.
And I'll just jump to the end.
Mr. President,
The
may
law now
request
says
that one of our private prosecutors be recognized to continue the cross-examination, Attorney Renato Samonte Jr.
Let it be noted that the request,
Thank you.
the request of the prosecution is noted. Proceed.
Good afternoon po ulit, Mr. President and Your Honors and Mr. Mayor. May I proceed, Your Honor?
Go ahead.
Ginoong Mayor Atienza, last time when you testified on direct examination, you made mention and presented at least 4 documents in the forms of endorsement from your city government in connection with this negotiated sale transaction involving Basagidote Enterprise. You remember having done that last time?
Opo.
In fact, exhibits 234, 235, 236, and 237 were marked in evidence by the defense. You remember also having identified these documents.
Yes, Your Honor.
And these endorsements were signed by your responsible officers, City Legal Officer Melchor Monsod for 234, Emmanuel R. Sison, your secretary. Another document by Attorney Sison. And the last one by City Treasurer Liberty Toledo, City Accountant Kilantang, and Budget Officer
Is there any question about those?
yes, we're about. I'm just.
Why don't you just go direct to the point that you want to bring up?
Yes, Your Honor. Now, Mr. Mayor, in all these 4 documents, you will agree with me that the entity mentioned here is only Basagidote Enterprise Incorporated. That's correct. There is no mention here of in trust for or Cristina Corona in trust for Basagidote. None.
Opo.
Last time also you mentioned of the check that you ordered to be issued in favor of the seller, Basagidote, as represented by Cristina R. Corona. That's correct.
Opo.
It was you as the city mayor who ordered for the issuance of this kind of check with that in trust for praise. That's correct.
Hindi po ako personal. Palagay ko yun ang naging desisyon ng City Treasurer sapagkat kailangan may managot doon sa check. So, dahil ang kausap po ng City Hall ay si Mrs. Basa Corona.
So between you as the city mayor and the city treasurer, are you saying that it was the city treasurer who made the decision to put the check in trust for?
Hindi po. Ang sinasabi ko
or was it not really your
ito po isang proseso na nagmula doon sa katotohanan na si Mrs. Cristina Basa ang kausap ng gobyerno lokal na hindi po kinakailangang manggaling pa yung order sa akin.
Okay. And that during the stint of your mayorship for 9 years, as you said, unprecedented at that, you have seen millions of checks issued by the city government. That's correct.
Hindi naman po siguro millions. Pero marami po.
Marami. Opo. At katunayan po, alam niyo po na sa bawat cheque, official check, land bank check, na ini-issue ng city government, lagi po itong dumadaan sa check writer, di po ba?
May proseso pong tinatakbuhan yan under regular rules that are being followed.
So that for every check issued, there is always this duplicate that is left behind, bearing the entries stated on the face of a given check. That's correct.
I would not.
You're familiar with that?
I would not be very familiar because this is all now part of the treasury responsibilities and functions. Wala po yun sa function ko na chikin na yung recording ay tama o naaayon. Ang aking pong concern, lalo na rin sa kaso ito, ay yung mabili yung lupa at makuha sa lalong madaling panahon para maitayo namin yung palengke na kinakailangan po ng sampalok sapagkat yung lumang palengke ay gigibain na.
But for this particular transaction, you would recognize that land bank check that you issued in favor of Cristina Corona or BGEI for that matter. Yan po yung kopya ng cheque na ibinayad ninyo sa BGI. Yan po yan. At sasangayon din po kayo.
Anong sagot ng witness? Opo, ito po yung cheque. O, sige.
At sasangayon po kayo sa akin na ito po yung duplicate copy or check writer copy na nagsasaad kung ano ang entrada doon sa mismong cheque. Di po ba? Certified po yan ng COA. Examinin nyo nga po kung parehong-pareho yan.
Tama po yung presyo.
Tamo po ang presyo, ang check number.
Check number is the
ang
same.
payee, di po ba?
Payee is Cristina Corona, ITF, Basa Guidotti Enterprises.
Opo. Ngayon, meron po, yan po yung certified copy ng galing sa COA.
Opo.
Ngayon po, meron din po kaming hawak na certified copy na galing din sa COA. The same, involving the same check, copywriter check. Pakitingnan nyo nga po kung halos kapareho nung naunang in-identify nyo.
No
pareho din
basis.
po.
Objection,
Already
Your
answered,
Honor.
Your Honor.
May we request, Your Honor, that the witness not answer immediately to give us the opportunity to object?
Yes.
We therefore
just give them an opportunity to address the nature of your question.
yes, Your Honor. Because it was readily answered anyway, Your Honor.
Yes.
So we would like to request, Your Honor, for the marking of this first copywriter check, earlier mentioned, identified by our good mayor, and stating that this is
Counsel, is there any difference between the two checks?
Yes, Your Honor.
All right, then go to the point.
We will mark this first, Your Honor, as Exhibit 11L, Your Honor. The first one. And the second one as 11LM. These are both certified copies from COA, Your Honor.
Manifestation, Your Honor, that these two checks are certified through copies is not borne out by the very document being shown to the witness, Your Honor.
These were admitted anyway, Your Honor.
No, it's not a question of admitting, but it's a question of misrepresenting that the document is a certified true copy.
Anyway, do not argue anymore. Just present those evidence. It will be the function of this court to appreciate the evidence.
Yes, Your Honor.
They're the same in all respects, no?
Your Honor, this is actually proper for our memorandum or summation, but we would just like to point out, Your Honor, that in the second certified copy admitted by our witness, there is something lacking In the first
What do you mean?
photocopy, Your Honor,
In the second, the same check
in the same,
was certified by the COA, one for the defense and one for purposes of your cross-examination. Is that correct?
yes, Your
And
Honor.
there's a difference between the two checks.
Yes, and the
What's
difference, Your Honor,
What's the difference?
and the difference is that in the first copywriter copy certified by the COA, there is the words Christina Corona ITF as appearing also in the check. But in the second one, Your Honor,
Which is your
yes, which is
material for
the copy that we...
wait a minute. Which is your material for cross-examination? That does not appear.
There is none, Your Honor.
All right. So,
May
So-
we request, Your Honor, that they be marked so that we can refer to them, to either one of them?
yes.
Because they are not marked, Your Honor. It will
All
be
right,
very big.
Mark them accordingly.
L, Your Honor, and 11M. With request for submarking of the praise Christina Corona ITF as 11L-1.
That is being marked on what a copy of the same document now
Copy of the one...
presented by the defense.
yes, Your Honor.
All right.
And for the other copy that we have presented today, we request that portion without this Christina Corona ITF to be encircled and be marked as Exhibit M-1.
That is the copy which you are using for your cross-examination.
Yes, Your
All
Honor.
right. Please be precise in your description of the facts so that we will not get confused.
Okay. With the kind permission of the Honorable Court, Your Honor. A while ago, we made the manifestation that the statement made by counsel in connection with the identity of the check is not yet borne out by the evidence. He claimed that these were check duly certified by the accounting office. There is no such thing, Your Honor. That's our point of objection, Your Honor. That is a manifestation.
All right. You have an objection about the use of the word certified copy. Counsel for the prosecution. What is the basis of your claim that
We
was...
say that this is a certified copy because an official document that came from COA.
Precisely. That must be established by... I'm sorry, Your Honor.
We are marking this, Your Honor, for purposes of comparison in today's proceedings.
Will you kindly please talk one after the other? Let counsel finish the statement of the other counsel. So,
I'm sorry, Your Honor.
All
I
right.
was just...
prosecution first.
Yes, Your Honor. We got this particular document from COA itself. This was certified. This is a certified copy and therefore an official document. And we confronted our witness here. And he admitted.
Why do you say it's certified copy?
It came from COA itself, Your Honor.
Is there a statement there that certifying that is the same document, an authentic copy of a document in the possession of COA?
What is stated here, Your Honor, certified through Xerox copy from the Xerox, signed and issued by Eva L. Santa Maria, State Auditor for Chief Administrative Division.
All right. Then
COA.
proceed.
That will be all for this matter, Your Honor.
All right. What's the pleasure of the defense?
I was about to make a short manifestation, Your Honor, in connection with said statement of the Honorable Counsel, Your Honor, because all what he is stating now came from him, and he's not under oath. We cannot cross-examine him unless he will take the stand, Your Honor.
He is describing the document, counsel,
Yes.
that he was using for cross-examination.
But the two documents, Your Honor, carries with it the word certified through copy, Your Honor. And this is not explained, Your Honor. It may cause ambiguity and confusion on the part of the court, Your Honor.
Precisely because the tendency of the cross-examination is to impugn the authenticity of the document that you presented as evidence.
Yes, Your Honor.
That is the purpose of a cross-examination.
Evidence ba namin
The
yan?
first one came from them, Your Honor.
Ha? No. Kanila. Pareho. Kanila pareho yan. Hindi amin. Yes, they are both I'm sorry, Your Honor. They are both exhibits for the prosecution, Your Honor. What we mark as evidence in connection with the existence of the check is a certified true copy of the check itself, not a certification by the COA. That's why we are vehement in our observation, Your Honor.
Wait a minute. Did you present the first document in your examination in chief of the witness, Mr. Counsel for the prosecution?
It was the defense who marked the copy of the check, Your
But
Honor.
did that document...
And in my, if I remember it right, as a preliminary question, I asked our good mayor if the first document that I presented appears to be a duplicate copy of the original of the check, and he said yes. And then I propounded my next question.
No, but the question of the chair is who presented to the witness the copy of the check which says ITF? Was it was it the prosecution or was it the defense?
We never have presented it, if Your Honor, please.
All right.
What we presented in evidence, Your Honor, is the very Xerox copy of the check in the amount of 34.7 million pesos.
Then, so that to avoid this discussion, let the prosecution clear this because both documents are your exhibits.
Well, Your Honor, be that as it may, we confronted the witness. We gave him the opportunity to make the comparison, and he said yes.
No,
so I propounded my next question thereafter.
But you did not, counsel, forgive me for interrupting. You did not lay the basis of your question. You should have qualified the witness first whether he had anything to do with the preparation of that document, to know the details that are written on the document. You assumed already a fact not proven yet.
Yes.
Your Honor, if I remember it right...
Anyway, so ordered. You reform the question.
Yes. I'm finished with that. Anyway, I'll go to another point.
In which
I'm
case,
through with that, with the marking, Your Honor. I will leave it to the appreciation of the Honorable Court.
in which case, Your Honor, we will object to the marking. We will move that it be stricken off from the record, Your Honor, because it is irregular, it is violative of the rules and evidence and procedure.
Anyway, if you are not going to mark this second copy of the check, then the chair will sustain the objection of the defense.
Your Honor, we have already marked it, and we will try to confront again our witness.
Because in effect, what you are doing now is impeaching the very evidence that you presented in the first place.
No, I will then rephrase, Your Honor. May I borrow again?
Just to clarify the record, may we make it of record that both these exhibits are not exhibits for the defense, Your Honor. They are exhibits for the prosecution, brought about only during the cross-examination, Your Honor.
Precisely, that is why the chair was mistaken in its assumption that the first copy of the check was presented by the defense. And that's why I had to clarify.
Thank you, Your Honor.
Your Honor, we do this in regular courts. May we ask our secretary to read back the answer given?
Compañero, do not teach me the techniques of trial.
I know, Your Honor.
That is not done in the regular courts. I'm sorry to tell you that. I do not know what court you practice, but you are contradicting your own evidence.
I just heard anyway, Your Honor.
Reform your question.
Yes, Your Honor. Mr. Mayor, I'm showing you a document that a certified copy that came from COA. And I asked you earlier if you will agree that the entries stated in this other copy is a reproduction of the one appearing in the original check.
Your Honor.
I'm sorry. So, my question is, do you agree or do you not agree?
Your Honor, please. no basis for the question. In the previous earlier question by the learned counsel, Your Honor, it was clearly stated by the witness that has nothing to do with the routine matters
Let
in
the
court.
witness answer.
Ano ang question?
Ulitin ko po yung sinabi ko kanina na hindi po ako ang nagpe-prepare ng cheque at yan po ay prosesong sinusunod ng City Treasury when they are supposed to be issuing the necessary payments. Hindi ko po alam kung ano ang pamamaraan nila.
No, I'm using, I want you to use your own perception today and look at these documents. Just for you to say whether the entries, from your own perception, whether the entries stated in this other document, a certified copy that I am showing to you, bears the entries stated in the original check.
With the kind permission of the
If
Honorable
he
Court.
knows, Your Honor.
Allow me to listen out.
What is the pleasure of the defense?
Your Honor, please. The witness now is being confronted with an alleged certified true copy issued by the auditor's office. There is no such evidence on record. That is their assumption. That's why we are objecting right from the very beginning, Your Honor. That is a fact not yet established by the record, and it is being made as a premise. So the question is misleading, Your Honor.
Wait a minute. Counsel, what you are in effect trying to tell the court is that there is a difference between the first copy of the same check for paying the property of the Cabasa Guidote sold to the city of Manila. With that copy that you now have to and being used by you in your cross-examination, isn't it?
Yes, Your Honor.
All right. So you are in effect impugning the first the material that you yourself presented to the witness. Oh,
I am giving him the opportunity to make the comparison, Your Honor.
Why you cannot do that? Are you saying that the first document that you presented to the witness is spurious?
No, Your Honor. We're just trying to show that there appears to be two kinds of underwriter photocopy of this same check.
Well,
that is the purpose, Your Honor.
Then what is the materiality of that point?
The point, Your Honor, is that it will even more show the infirmities attendant to this kind of transaction, Your Honor.
In other words, what you are saying is that this the money that was issued to Mrs. Corona was not really in trust for, di ba?
Yes, Your Honor.
That is your point.
Yes, Your Honor.
Mr. President.
And
but you were the ones who presented that evidence, so you are bound by that document. So order.
Mr. President, may we recognize Senator Miriam Defensor Santiago.
Counsel for the prosecution, let the court educate you. You are asking the wrong witness. You are presenting two copies, and according to you, these are certified true copies from the Commission on Audit. So call someone from COA and ask them if this is certified true copy, and then explain why two certified copies from the same office appear to be different from each other. You cannot get the answer from this witness. You are forcing him to make a conclusion of fact when he has already testified for the record that has nothing to do with the preparation of these documents. You are harassing the witness. That is what you are doing.
I'm sorry, Your Honor.
You should be sorry.
That is not my intention.
Whether it was the intention or not, that was the result.
With due respect.
Anyway,
I
go
submit,
ahead.
Your Honor.
All right, go ahead. Finish your cross. Proceed.
Now, may I proceed then, Your Honor? Early on, during direct examination, you identified the properties which, according to you, kailangan for your LRT New Sampaloc market. That's correct.
Kailangan po ng lungsod ng Maynila.
Opo, ng lungsod ng Maynila.
Hindi po,
At nag-umpisa...
Let me just correct it. It's not the LRT. It's the city government.
Yes, Your Honor. I stand corrected. And you started doing what was necessary in May of 1999. That's correct.
Opo.
You sent out letters to the registered owners of the properties in that vicinity of Bustillos, Ligarda. That's correct also.
Ang naaalala ko po, may sulat na pinirmahan yung aming city administrator upon my orders to look for the owners of that property which we thought was ideal for a relocation of the Sampaloc market.
Okay, and a number of letters were sent to the prospective landowners almost simultaneously.
Ang naaalala ko po yung sulat ni Colonel Fernando sa Basa Guidotti Enterprises.
And in the adjoining property owners also. Di po ba?
Opo.
Katunayan po, ay dun sa ginawa niyong expropriation ordinance, meron po kayong mga listahan ng titulong nilagay doon, di po ba? You remember that?
Opo, dahil meron pong ilang mga properties na that could serve the purpose.
Serve the purpose. And one of which nga po, ito pong Basa Guidotte.
Yung pinakamalaki po sa akin.
Pinakamalaki. And you had in mind kung magkano po ang magiging halaga nitong mga properties na to serve the purpose, the public purpose.
At that point, alam ko po ang presyong nananaig dun sa lugar dahil binenta po namin yung Old Sampaloc Market sa LRT. Sa gobyerno din po. At binenta namin for 50,000 per square meter. So somehow, alam po namin ang ongoing reasonable rates. Tinanggap po naman ng LRTA yung presyo namin.
Katunayan po, meron po kayong pinailan na expropriation at ito pong, meron po kayong pinailan na expropriation case. That's correct.
Misleading, Your Honor.
I'm asking.
Why? There was no expropriation case that was filed.
There,
You may know there.
we will confront now, Your Honor. There is a petition for eminent domain.
Let the witness answer. Hindi po yun expropriation case against the Basa.
Hindi, sa iba po, sa iba.
Yun po yung expropriation ordinance that allows the city government to take possession of certain properties.
Mr. Mayor, do you not remember this case number 0098311 filed by the City of Manila against or versus Guidotte Mercantile Corporation, Everlasting Development Corporation, Eupemio C. Uy, and George G. Eupemio?
Before the witness answers, Your Honor, may we be informed as to the materiality and pertinency of this document?
We will show a little later on, Your Honor.
No, but the witness is very...
Let the witness answer. That's...
O alam daw ba ninyo yan ang tanong? Tignan ninyo.
In fact, you were the one who verified this complaint, as shown at the last page. Verification and certification. Jose L. Atienza Jr., affiant. Do you now remember?
Pwede po bang basahin ko muna?
By all means. Additional information that was filed and rappelled before Branch 28 of the Regional Trial Court of Manila.
Andito po yung aming city legal. Pwede po bang makausap ko siya para maliwanagan ko itong dokumentong inihaharap sa akin?
Let the witness confer with the Council of Manila.
With the kind indulgence of the Honorable Court.
Yes.
Examining the questions being propounded and trying to decipher the answer that will be elicited from the witness, it would appear that the prosecution is making ex-Mayor Atienza their witness now. Not through, but not in the concept, but not a simple cross-examination question, Your Honor.
Well,
this is allegedly.
Let us let us hear first. There are 4 techniques of cross-examination. You probe, you insinuate, you undermine, you confront.
Yes,
let them probe the witness. Go ahead.
Mr. President?
Yes?
Gaya po nung sinabi rin ng aking legal officer, ako po mismo, hindi ko po maalala itong expropriation case na ito sapagkat napakarami po kami ifina-file ng mga kaso nung aming administrasyon sapagkat gumagawa kami ng programang pabahay at sa lahat ng gamit ng pamahalaan.
Next question.
Would you not remember that there was really a case for expropriation?
Frankly,
would you not even remember that?
Frankly, I don't remember.
Already answered. He does not understand.
Will you not also remember that in an expropriation case, there was a compromise agreement eventually entered into by the city mayor, and you arrive at the amount of 25,000 per square meter for this property belonging to Everlasting Development Corporation, to UPEMU, CY, as evidence by this judgment in civil case number 0098311. You won't also remember that.
Gaya ng sinabi ko po, sa dami ng dokumentong pinipirmahan ko as mayor, every day, and sa dami rin ng aming mga land cases, hindi ko po maalala specifically itong kasong ito ng expropriation case.
But just the same, Your Honor, may we request for the marking of these 2 documents as exhibit 11N and 11O, respectively. The first document, the complaint, Your Honor.
Mark them accordingly.
And the second document, the judgment itself on the same case.
By the way, what is the relevance of these 2 documents?
Relevance, Your Honor?
To the impeachment trial.
Your Honor, it is related in a way, Your Honor, because...
In what way?
Your Honor, the amount, it is actually has something to do with the testimony of our mayor. As in this eminent domain case, the amount arrived at was only for 25,000, wherein in this Basagidote case, they arrived at 35,000.
So what? If they paid 34,700,000, that is the only thing relevant into the impeachment case. If they overpriced, that's another issue.
But that, in effect, Your Honor, the city government of Manila was shortchanged.
Well, that has nothing to do with the...
Your Honor, it has something to do with the statement, with the testimony of our good mayor.
You are impugning his credibility.
Yeah.
Okay.
A while ago, Your Honor, we were questioning the materiality and the pertinence, but it's not yet shown. What is the materiality? Does it mean to say that the mayor made money?
He is trying to impugn the
testimony itself, Your Honor.
The credence of the witness. So, okay.
Yes.
We will allow him to proceed.
Yes,
Your Honor. One last point.
Mr. President, may I also react to that statement of the statement of counsel imputing wrongdoing on my part or overpricing, as he said? I find it most unfair, Mr. President, that he can accuse me of that in this court, wherein I have never done such act. Never.
We're just trying to show the disparity in the amount. I will leave it to the proper court.
In the same manner, Mr. President, he should also show expropriation proceedings where I got properties way below zonal value. I got properties from the Catholic Church for 75 pesos per square meter for the poor. Why don't you mention that also, counsel?
This court is trying to give everybody sufficient leeway to ask questions to elicit facts. But let's just avoid this discussion. Proceed with your question, Mr. Counsel.
One last point, Your Honor. Ito pong nangyari sa Basagidote Enterprise na kung saan ang cheque ay ginawa niyong payable to Cristina Corona in trust for Basagidote Enterprise Inc. Ito po ba'y kostumbre, practice, policy ng City Hall na kung mayroong kayong katransaksyon korporasyon, lagi niyo pong hinahanapan ng responsible officer by way of additional safeguard, like putting the check in the name of Cristina Corona in trust for BGEI. Ito po'y palagi niyo bang ginagawa o dito lang?
With the kind indulgence of the court, we object to the question, Your Honor. No basis.
Let the witness answer. So
Ang tanong po ginawa ninyo.
Mr. Counsel, this will not hurt your case anyway. Let the witness explain. So ordered.
Unang-una po, hindi po naman ako ang gumawa ng cheque. No? Ang City Treasurer po yan. City Accountant po yan. City Budget Officer po yan. At dumating po yan sa akin para pirmahan na at para magkaroon ng katuparan yung aming paggamit ng lupa.
Ang tanong ko po ay...
Wait a minute. You have two checks or two certified copies of the same check coming from the COA.
Yes, Your Honor.
The ITF marking in the first copy of that check was not written by COA.
No, Your Honor. It came from the very original of the check.
All right. So you admit that?
We do, Your Honor.
All right. So...
but in the other one, it does not appear.
Why don't you ask the treasurer why he put the ITF in the one check and did not do it in the other?
We just tried to ask our good mayor, and we will yield to.
He is incompetent.
Yes, we will yield to the.
He is incompetent.
Comment of our good Senator Miriam Santiago, Your Honor. In due time, we will do that.
All right.
We just tried our luck. If we can ask him, Your Honor.
Proceed.
I think that will be all, Your Honor.
Thank you. That is all?
Yes, Your Honor.
You're through?
Yes, Your Honor.
You do not need the witness anymore?
None anymore, Your Honor.
Yeah. Is there any redirect?
Just a few questions, Your Honor.
All right, proceed.
Mayor Atienza, during the cross-examination, you were shown allegedly 2 copies of a check coming from the COA.
Opo.
In paying for the property that you purchased from Basagidote Enterprises, Inc.,
Opo.
as far as you know, how many checks were issued by the City of Manila?
Sa aking pagkakalam po, isang cheque lang po yun.
And before issuing the check, was there a disbursement voucher?
Meron po.
And did you sign the disbursement voucher?
The disbursement voucher, yes, Your Honor.
I'm showing to you our Exhibit 239, the disbursement voucher. And there appears here a signature above the typewritten name Jose L. Atienza Jr., City Mayor. Will you please identify this signature?
Opo.
Whose signature is that?
Sa akin po.
Does the disbursement
Your Honor,
voucher?
please.
Yes.
May I interpose my objection, as in the first place, I did not touch on this particular document on my cross.
Preliminary.
So it will be improper.
The witness answer.
Opo, pirma ko po ito. Naalala ko po itong voucher.
Okay, does the disbursement voucher identify the number of the check that was issued by the City of Manila in payment of the property that was purchased from Basagidote Enterprises, Inc.?
Mr. President, can I just inquire from my
Proceed.
legal officer?
Proceed.
Ito na lang. Hindi na to.
Thank you, Your Honor. Opo, andito po. Nahanap namin yung check number.
Will you please read the check number?
Check number 188804.
Okay.
My counsel, just with your permission, I just want to clarify one thing from the distinguished witness. Does that disbursing voucher describe the payment as in trust for the Basagidote?
Andito po.
Nakalagay in trust for.
Opo.
Okay, I'm now showing to you a certified true copy of a land bank check number 000188804, already marked by the defense as Exhibit 238 and also by the prosecution as 10Js. Please tell us if this is the check referred to in that disbursement voucher.
Mr. President.
Yes.
Opo. I see the check, the copy of the check, and it bears the same number.
I just want to make another clarificatory question, Mr. Witness.
Okay.
If that, if we check and the voucher states that the payment is in trust for, who was the actual payee of the check?
Ang nakalagay po dito, yun po Cristina Corona ITF, Basagidote Enterprises.
So the payee was Cristina Corona in trust for
Basagidote Enterprises.
In other words, the trustee of the fund is Cristina Corona.
Opo.
All right.
May we request, Your Honor, that the words Cristina Corona ITF Basagidote Enterprises Inc. as appearing in the disbursement voucher, Exhibit 239, be bracketed and marked as Exhibit 239-A, and the check number 188804 referred to in this disbursement voucher be marked as Exhibit 239-B. We also request, Your Honor, that the check number as appearing Exhibit 238 be bracketed and marked as Exhibit 238-B. And the payee, Cristina Corona ITF Basagidote Enterprises Inc., be encircled and marked as Exhibit 238-C. One last question, Your Honor.
Go ahead.
Noong Marso 22, 2012, in the course of the cross-examination, meron hong tinanong si Senator Drilon tungkol sa isang notice of suspension. Kailan ho ba ninyo unang narinig yung notice of suspension?
Sa totoo po, doon ko lang po narinig yung order of suspension. I've never heard, never seen, and never sent an order of suspension.
Have you received this notice of suspension to date?
Up to now, I have not received.
Ano yung notice of suspension?
COA ho. Notice of suspension by the resident COA.
To suspend payment?
It was just a notice of suspension raising some points regarding the transaction, Your Honor.
All right.
Your Honor.
That will be all, Your Honor.
Well,
Mr. Vice Mayor, Mr. Mayor, doon ba sa cheque na naglalaman ng bayad ng lupa sa Basa Guidote at ganoon din yung voucher, kasama ang pangalan ni Chief Justice Corona?
Andito po sa voucher, opo.
Kasama ang pangalan ni Chief Justice Corona?
Opo. Hindi po si Chief Justice. Christina Corona po.
Wala si Chief Justice?
Wala po.
Wala. Ang trustee dyan ay si Christina Corona.
Christina Corona po.
Hindi si Chief Justice?
Hindi po.
Okay.
may we have a number of requests, Your Honor?
Go ahead. Proceed.
Mr. Mayor, you will agree with me that in the particulars of payment in this disbursement voucher, the only entity as pay mentioned herein is Basa Guidote Enterprises, Inc. That's correct. In the particulars of payment.
Nakikita ko po rito ngayon
Just answer yes or no.
Ito'y kabayaran sa Basa Guidote Enterprises. Opo.
Nothing is mentioned in the particulars of payment of this entrust for Christina Corona. That's correct.
That's misleading, Your Honor.
No, he's asking a question. If it's in the document.
And with respect to this check that you identified, when Christina Corona signed this disbursement voucher, she also received simultaneously the check. That's correct?
Opo, sapagkat
That's misleading, Your Honor.
I'm asking, Your Honor.
What is misleading about it? What is
That's why I'm asking.
What is misleading about the question?
The disbursement voucher, Your Honor?
No, the basis of the objection is that the question is of the cross-examiner is misleading. Why?
What I heard, Your Honor, is that the check was simultaneously delivered upon the signing of the...
That's why she's asking for the question.
That's why.
She's eliciting an information.
Hindi ko po maaalala yun sa totoo lang po. Sapagkat dumaan sa akin yung voucher, tapos nabayaran na yung property.
And when Christina Corona received personally this land bank check, which according to you, you even had a simple ceremony in the City Hall. You remember having said that?
Wala.
Am I correct?
Meron po kaming pagka-turn over ng check. Opo.
And the Chief Justice, the respondent, was present during that time.
I don't remember that.
How many times did you see the respondent accompanying Christina Corona, aside from the fact when they went to your office?
Counsel, what is the relevance of that, whether the Chief Justice was present or not?
We are showing the involvement of the Chief Justice because, Your Honor, the Chief Justice has been saying in the media that he's not getting involved. So we would like to
presence.
know if at all he was accompanying the wife.
Yeah, precisely. He's present there probably to accompany
But
the
for whatever reason, Your Honor.
All right. Anyway, answer, Mr. Witness.
On the several occasions that we talked about the transaction, the negotiation, si Mrs. Corona po ang kausap ko. And a certain attorney Corona then, who was the husband, was present on those 2 occasions.
So the Chief Justice was present during that time. Attorney Corona, for that matter.
Attorney Corona, because yung po pagkakakilala ko, that was the first time I saw the gentleman.
That will be all, Your Honor.
All right. Anything else? If there's none, the witness is discharged. Next witness.
Thank you.
Thank you, Mayor. Lamski, 1 minute lang.
Next witness.
Mr. President, may we suspend the proceedings for a few minutes?
How many minutes?
Okay, tanong natin kay Dean yung mga relevance itong checking ito. Dean, may sinabi na unang check di ho ba? Tapos may COA check. So, paano po yun? Parang sabi nga ni Senate President Enrile, kinontra nung prosecution, yung kanilang sariling ebidensya.
Ganito, I'll just give the background. Napasok ito sa kwento, itong Basag Gitote property, dahil ang explanation ni Chief Justice Corona for part of the money, the wealth that he used to buy his properties, was that it was part of the proceeds of the Basag Gitote property, which was owed by Mrs. Corona's family. And then, binili ito ng City of Manila dahil yung LRT was being built. The LRT was going to hit the Sampaloc market. They had to relocate it. Manila had to find the property. They found the Basa Gitote property for that. Ang nangyayari ngayon, pinapalabas noong ng prosecution, questionable yung transaction.
Yes.
So questionable on several points. Sinabi nila, bakit ang cheque nyo payable to Mrs. Corona, not to the corporation owning the property. At pangalawa, yung sinasabi nila na, di ba yung valuation ng property mukhang pinataas. May initial valuation na mas mababa, bakit mas mataas yung binayad? Kaya nga medyo nag-react si Mayor Atienza parang
sa overpricing.
Oo, na parang may ini-imply na may fraud doon. At yung pangatlo, mayroong parang stop order yung COA saying na paki-hold yan, meron kaming gustong i-review sa dokumento. I think nagkagulo sila, Arnold, dun sa related to the point that you're raising. Dahil ang pinresenta so far was the check issued by the City of Manila in payment. And then later, ang pinapakita na nung on cross-examination was not really the check, but merely a certification from the COA. So ako naman, of all the points raised, ang relevant lang talaga yung why pay in the name of Mrs. Corona, when in fact it was for the Basa Gitote estate.
So why didn't they just put payable to Basa Gitote Enterprises?
Yes, yung in trust for
yes,
di ba?
Yeah.
Pero it was Cristina Corona's name in trust for Basa Gitote Enterprises.
Yes, and ako naman at this stage, it's just a presentation of evidence. They just wanted to establish that hindi na paliwanag. In fact, di ba, tinatanong nung prosecution, ginagawa nyo ba to usually? Hindi naman natuloy yung line of questioning na yon kasi hindi naman yun ang testigo was the mayor, hindi naman siya in charge doon. Ang comment ni Senate President Enrile, bakit pa kayo magtatanong doon sa valuation? Wala namang
relevance.
Walang relevance yan. Dahil the only fact relevant to the impeachment is how much money was actually brought into the Corona family based on the Basa Guidote transaction.
So hindi naman ho natin sinasabi na may dalawang cheque na para magkaiba yung mga entry. Ang sinasabi lang natin, yung unang cheque nasa pangalan ni Cristina Corona, yung isa naman na some kind of record lang siya, no? Na nakalagay Cristina Corona in trust for Basa Guidote.
Yes, yun ang gustong ipalabas ng prosecution. Para bang, bakit sa buong process, it was all for the benefit of Basa Guidote. Tapos paglabas ng cheque, it was already in trust for.
Pero is that irregular?
Ako naman, I will assume, but it wasn't covered in this testimony, it was covered in an earlier testimony, that she presented the paper. Mrs. Corona presented a certification that she was authorized to transact in the name of
Okay.
the estate.
Baka yung nanonood, anong kinalaman nitong Basa Guidote Enterprises? Ito ho kasi, yung pera dito, kung mapapatunayang pera nga ng korporasyon,
yes.
Di ba, din ito yung sinasabing bakit hindi nasa SALN ni Chief Justice Corona.
Yes.
Ang katwiran nga ni Chief Justice Corona po, ito'y pera ng ng misis niya at ng korporasyon, kaya hindi kasama sa kanyang SALN. Hindi ho ba?
Yes.
Kaya pinag-uusapan itong Basa Guidote. Pati dun sa records ng bangko, yung perang umiikot. Di ba? Ito yung depensa ni CJ Corona na pera din, na pinagbentahan ng Basa Guidote. Kasi baka ba't pinag-uusapan yung Basa Guidote?
Oo. I think, if I remember right, it was also a way of explaining bakit may perang pumasok sa
bangko,
sa kanila. Hindi na ba sakop nung kanyang
sweldo.
So ito ang sagot, galing sa misis ko dahil nagkabentahan ng property.
Maski yung parang hiniram niyang pera na 11 million pesos, hindi rin siya ipinakita doon sa SALN. Now, ang claim ng company Corona is that itong 11 million ay nanggaling dito sa sale ng property na inutang niya di umano dito kay Basa Guidote Enterprises.
That is correct, Vicky. In fact, I think first or second week of the trial, nung hinarap ng prosecution yung tiga-SEC, hinarap yung testigo, sinabi na ito ba yung certification nung korporasyon authorizing Mrs. Corona to transact. If I remember right, tinanong pa, ano ba yung scope ng authority? And ang ni-raise na point nung prosecution was receiving the check in her name, in trust for the corporation, was not within the scope of that authority. That was the argument at that early stage of the trial.
Din kanina naputol tayo dun sa pagpapaliwanag nyo dun sa ombudsman.
Yes.
Dahil nagsimula ito. So, anong malinaw dito? Pwede makialam yung ombudsman in particular sa paghingi ni Conchita Carpio Morales ng explanation kay CJ Corona dun sa complaint, no? Dun sa $10 million bank deposit. Gayong may isinusulong ng impeachment at yung hinihingan niya ng pagpapaliwanag ay isang impeachable officer.
Mayroong kapangyarihan ang ombudsman na mag-investigate kahit ng impeachable officer. So ang debate dyan dati was that all public officers are within the jurisdiction of the ombudsman to investigate. Kaya lang, the highest public officers, the President, Vice President, Supreme Court Justices, constitutional offices, are to be disciplined in only a specific way, to insulate them from political pressure. There is a special way to hold them accountable. That is through the highest mode, which is impeachment. In other words, mahirap pag-impeach. At itong method of enforcing accountability is reserved only for the highest offices. Kaya for a while, iniisip, kung impeachable officer, hindi dapat pwedeng ma-investigate, pwedeng i-charge ng ombudsman. Ngayon, ang state of the law is that the ombudsman, of course, cannot punish them, cannot charge them in court. Kasi they can be charged only before an impeachment court. And the only party which can impeach them is the Congress. They will be charged by the Congress, tried by the Senate. But if only for the purpose of an investigation, sakop yun ng powers of the ombudsman.
So the ombudsman can investigate but cannot
Kahit hindi
charge.
pa tapos.
That is correct, yes.
Official.
Kasi dati tapusin mo na impeachment bago ka pwede mag-charge, di ba?
Well, wala pa naman kasi
Pwede
na
magtuloy.
i-impeach.
Wala pa impeach eh.
In fact, yan ang nire-raise naman ng point ng defense. Sabi nila, well, tama yan. Pwede mag-investigate, pero ang impeachment court lang ang pwede mag-charge at try nung impeachable officer. Pero ang sagot nila, sagot ng defense, abang ngayon may impeachment proceeding ongoing. So, I've read the comments na sabi nila, this is a different scenario. But yun na nga, I think nag-react na si Senator Enrile. Again, this is outside of the court. In an interview, sabi niya that let the ombudsman proceed with the investigation. That is the ombudsman's show. Kami sa Senado, itutuloy namin yung impeachment. So, right now, ang lumalabas, these are two entirely separate proceedings. They will proceed on their own.
So ano naman ho din yung bearing nitong 10 million allegation na ito dito sa current impeachment proceedings?
Pwede mo ba? Wala sa articles yun, di ba?
Well, ganito yan eh. Wala sa articles dahil, on one side, wala sa articles dahil sinabi na ng impeachment court that they will not hear any evidence on ill-gotten wealth. Pero pinapasok ngayon as part of the undeclared assets under the SALN. So that is the way na mapapasok siya. Dadaan niya sa SALN, hindi sa ill-gotten wealth.
Pero ba't sinasabi, ang inaabangan ngayong isa sa mga ebidensya, yung bagong SALN na isinabmit ni CJ Corona. Doon yata may mga konti daw na revision. Although, pwede ba itong pabuksan ng impeachment court gayong may resolution pa rin ng Supreme Court?
Well, okay. The resolution pertains to the dollar deposits.
Hindi, so, pati yung di ba yung
yes. You're referring to the old Supreme Court
ng mga
resolution.
Justices ng Supreme Court, di ba?
Okay. On that point, yes, sakop yan ng standing resolution of the Supreme Court. Nakakapagtaka nga na hanggang ngayon ay hindi pa nila nire-revoke yung resolution na yon. Dahil nakita na naman na the confidentiality of the SALN is contrary to the constitutional principle of public accountability.
Okay, manatili po muna nakatutok dito sa GMA News TV.
Magbabalik po ang The Chief Justice on trial.
Would you dare to step out without makeup? No makeup? No way! So they took the Dove 7-Day Test with 1/4 moisturizing cream for softer, glowing, youthful-looking skin. Kaya after 7 days, bye-bye makeup. Dare to bear glowing skin.
And what score? My skin score? 6 out of 10, I guess.
I used to be a 4. No, really, lots of fine lines.
New Vaseline Healthy White Perfect 10 for younger, whiter skin.
Now I'm a 9.
No, it's 10.
New Vaseline Healthy White Perfect 10.
Nagbabalik po ang The Chief Justice on Trial. Dumako muna tayo sa ating mga ibang balita. Sinabayan ng pangalampag ng ilang militante ang pagbubukas ng sesyon sa Kongreso ngayong araw. Ang panawagan po nila, madaliin na ang pagsasabatas ng hiling nilang 125 peso across the board wage increase. Ayon sa grupong Kilosang Mayo 1, kailangan na ito ng mga manggagawang Pilipino lalo na't lumalala raw ang kahirapan sa bansa at patuloy na tumataas ang presyo ng mga pangunahing bilihin. Asahan na raw ang sunod-sunod na kilos protesta hanggang hindi pa naaprobahan ang bill na ito. Sa ibang balita, nag-alok na ng 300,000 piso na pabuya ang lokal na pamahalaan para sa makapagtuturo sa mga suspect sa pagpapasabog sa Iligan City nitong Sabado kung saan 2 ang nasawi. Pinag-aaralan na rin ng mga otoridad ang CCTV footage sa paligid ng pinangyarihan ng pagsabog. Hindi nito nakunan ng aktual na pagsabog pero makikita ang sitwasyon bago at matapos ang kaguluhan. Ayon sa Iligan Police, 2 suspect na sakay ng motorsiklo ang nakita ng isang saksi. Wala raw helmet ang dalawa. Nagpagulong daw sila ng granada patungo sa direksyon ng mga biktima. Isang M67 fragmentation grenade daw ang pampasabog. Sa ibang balita pa rin, patuloy ang pakipag-usap ni na Claudine Barreto at Raymart Santiago sa kanilang abogado kaugnay ng plano nilang kasuhan ang kolumnistang si Ramon Tulfo. Kaugnay po yan ng gulong kinasangkutan nila sa NAIA Terminal 3 kahapon. Nauna nang nagsampa ng reklamo si Tulfo laban sa mag-asawa at viral na sa YouTube ang video ng bahagi ng gulo. Hindi po matiyak sa video kung sino talaga ang nag-umpisa ng away at kung nakunan nito ang buong pangyayari. Samantala, isang resolusyon ang iahait ni Agham Party List Representative Angelo Palmones sa Kongreso kaugnay nito. Nais daw paalalahanan ni Palmones ang public personalities na maging responsable sa kanilang mga ikinikilos, lalo pat mataas daw ang tingin sa kanila ng publiko. At yan ang iba pang malalaking balita sa oras na ito para sa News TV Live. Ako po si Ivan Mayrina. Balik sa inyo, Arnold at Vicky.
Thank you very much, Ivan.
Maraming salamat. Balik na tayo sa impeachment proceedings.
Alright. Pansamantalang nagsuspend na nga itong pagdinig dito nga sa impeachment proceedings.
Oo. At ayun, may hinintay silang panibagong witness para po, ito sa panig po ng depensa. At sabi nga kanina, 12 itong posibleng iharap nila bago magkaroon ng adjournment itong Kongreso sa June 7.
Pero maaring...
konting panahon na lang yan.
Maaring i-trim down pa itong listahan ng mga witness dahil maaari raw tanggalin na lang nila yung mga corroborative witness na tinatawag, no? Para siguro matira na lang sa 5 or 6. Pero titingnan natin.
Nanumpa na yung sino kaya itong saksing ito ng depensa. Punta natin ang impeachment proceedings.
May we ask permission that Attorney Dennis Manalo of the defense panel be allowed or permitted to conduct the direct examination.
Granted.
Thank you, Your Honor.
On the part of the prosecution, may we request that Attorney Winston Hines be recognized also. Your Honor, Attorney Hines.
Granted.
Your Honor, this witness is offered to prove that the Bureau of Internal Revenue issued a ruling dated May 22, 2001, stating that no capital gains tax may be levied on the excess of the just compensation paid by the City of Manila to the Basa Guidotti Enterprise Incorporated for the expropriation of its Sampaloc property, which is now being utilized as the Sampaloc public market.
And the purpose of your presentation of this witness is to establish that the 34,700,000 consideration was totally was intact and placed under the custody of Mrs. Cristina Corona in trust for Basa Guidotti.
Yes, Your Honor.
All right. Can you not stipulate this? This does not have to be proven.
In fact, Your Honor, we would like, if I may be allowed.
Yes, please.
In fact, we would like to object, Your Honor, to the offer of the testimony because the ruling, Your Honor, is inapplicable to the facts of the case as already testified by the good mayor of Manila. Because the premise, Your Honor, of the ruling is that it will be an involuntary sale of the property or as a result of an expropriation. As the good counsel of the defense, the just compensation would not be deducted of any real or of any capital gains taxes.
So, but anyway, whether a capital gains was due or not due, the fact is, and this is so far the fact that is understood by this court to be established, that the property was sold for 34,700,000 and that amount was paid for by check and received by Mrs. Cristina Corona in trust for Basa Guidote and placed under her control. So, whether there is a tax component of that amount, it doesn't matter because we're talking here of the quantum of assets and liabilities and net worth of a particular respondent.
Yes, Your Honor. And
So what's the materiality of all of this?
We agree, Your Honor. That's why we are objecting. It's not it's immaterial, Your Honor, to the fact in issue in this case, as well as it is not applicable at all, Your Honor.
We are wasting our time in,
we agree, Your
in
Honor.
all of these things.
well, if the objection, Your Honor, is just as to the
Anyway,
effect of the document, we offer for admission, Your Honor, by the prosecution, the authenticity and due execution of the Bureau of Internal Revenue ruling number DA-095-2001 dated 22 May 2001 regarding the capital gains tax in relation to the property of the Basa Guidote Enterprises Incorporated.
All right,
Inc.
Let us.
I have here, Your Honor, it has been pre-marked as our Exhibit 242 for the defense, and a copy of which is in the possession of the prosecution.
All right. There's Senator from Iloilo. Senator
Mr. President, may I support the Senate's President's suggestion that this document be admitted in evidence. Whether or not it is applicable to the case is a matter that will be argued in the memorandum or in the oral arguments. But the fact is that this document exists so that we can dispense with this witness, Your Honor. We just admit it and let the conclusions be drawn by both parties or by each party when the memorandum comes.
Okay, we submit, Your Honor.
Well, what about the defense?
Yes, Your Honor. We are willing, Your Honor, to agree if the prosecution will admit the authenticity.
What about the prosecution?
We admit, Your Honor.
All right.
Does the prosecution likewise admit that this BIR ruling has not been superseded, amended, modified, or otherwise revoked by the Bureau of Internal Revenue?
We don't know. We don't know, Your Honor.
Or if you do not know, then the witness is here to testify. If you are going to admit, then we can dispense with the witness.
All right. This chair will ask the question. You are sworn. Do you know about this ruling of the Bureau of Internal Revenue, which is being the subject of discussion in this proceeding?
Your Honor, based on the record.
Do you know?
Louder. Yeah.
Your Honor, this ruling was.
Do you know of this ruling?
Based
Yes.
on the records, Your Honor, yes.
All right. Then what is this ruling about?
This ruling exempts from capital gains tax the transfer of a real property which was acquired by the City of Manila through expropriation.
Why was it exempted?
The reason, Your Honor, is discussed in the ruling. It invoked the principle of involuntary conversion.
Why was it involuntarily disposed?
Because it was acquired through expropriation, Your Honor.
So that is the position of the Bureau of Internal Revenue, and as a consequence, you issued the ruling.
Yes, Your Honor.
All right. So what's the pleasure of the parties?
Your Honor, may we also ask the witness if this ruling has been superseded, modified, or revoked in any manner by the BIR?
Based on the records of our office, this ruling has not been revoked.
So what's the pleasure now of both parties?
Your Honor, we are willing to stipulate that the ruling was issued by the BIR and that its applicability only, as stated in the ruling itself, is in case of expropriation of the subject.
In other words, we all admit here that Basa Guidote did not pay any capital gains tax on the sale of the property. Okay?
Yes, Your Honor.
How about the prosecution?
Yes, Your Honor.
How about the defense?
Yes, Your Honor.
All right, so ordered.
With the admissions entered into by the parties and the clarifications made by the witness, Your Honor, may we move that the witness be discharged?
The witness is discharged.
Thank you, Mr. Witness. Si Beetle na muna, kasi basa gidote rin yun. Yung akin na lang. Your Honor.
Yes, please.
At this juncture, we will call to the witness stand Mr. Noel Quintanar, a representative of the Fort Bonifacio Development Corporation.
Fort Bonifacio.
Yes, Your Honor. The seller of the property purchased by one Cristina R. Corona, which is Unit 1902 of the Bonifacio Ridge Condominium in Taguig.
Is this the Bellagio property?
No, this is the Bonifacio Ridge property, Your Honor.
What is the purpose of the witness?
The purpose, Your Honor, is to prove that there was a delay in the delivery of the Bonifacio Ridge property, which is the real property number 4, reported in the Statement Assets, Liabilities, and Net Worth of Chief Justice Corona as of December 31, 2010.
All right. What is the pleasure of the prosecution?
Your Honor, may we request that Attorney Hernandez be recognized for the prosecution.
Yes, granted.
Good afternoon. Good afternoon. Your Honor, similar to the evidence regarding the alleged delay of the acceptance of the columns unit, we feel our position is that the evidence on any delay in the delivery of the condo units is irrelevant. And I think the presiding officer already took this position. Whether or not there was any delay, as long as payments were already made, this already constitutes an asset.
In other words, what you're saying, the court, is even if this witness will testify that there was a delay, it will not hurt your case.
Yes, Your Honor, it will be relevant.
Then let the witness testify so that we can finish the case.
Please rise. Mr. Witness, please rise. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
I do.
So help you God.
Mr. Witness, for the record, please state your name and other personal circumstances.
I am Noel Eli B. Quintanar, married, and I reside in Taytay, Rizal.
Your Honor, the witness is offered for the same purpose that we have already manifested before the Honorable Court earlier.
The same comments on the part of the prosecution, Your Honor.
Proceed.
Mr. Witness, do you know the Fort Bonifacio Development Corporation?
Yes, from July 2008 to December 2010, I was the head of commercial operations of FBDC.
And as head of commercial operations, what are your functions? Briefly, Mr. Witness.
As head of commercial operations, I oversee the sale of real estate assets in Fort Bonifacio Development Corporation, one of which was the Bonnie Ridge condominium.
Okay, you mentioned the Bonnie Ridge. Is this the Bonifacio Ridge condominium of the Fort Bonifacio Development Corporation in Taguig?
Yes, that is.
What is the status of this commercial project of the corporation as of this date?
When I left Fort Bonifacio in 2010, the development had been fully sold, to my knowledge.
Okay. Now, based on your functions as the head of the commercial operations of this company, would you know who the purchaser of Unit 1902 of Bonifacio Ridge is? Who is the registered owner?
Based on the records of Fort Bonifacio, the owner of that unit is Mrs. Cristina Corona.
What record are you referring to specifically?
In our records, there is a deed of absolute sale.
If I show to you a copy of this deed of absolute sale, will you be able to identify the same?
I will be able.
It was already established that by the witness, and there's no objection that they admitted that the owner of the unit is Mrs. Corona.
Yes, Your Honor.
What is the purpose of presenting another document to prove that he's the owner?
I am just going to confront him with Section 7 of the Deed of Absolute Sale.
Go ahead. Go ahead.
Yes, Your Honor. I am showing to you the Deed of Absolute Sale. This is the document which you referred to.
This is the document, sir.
The document, Your Honor, has also been marked by the prosecution as Exhibit UU, and we move that it be marked as our Exhibit 243. Your Honor, Mr. Witness, rather, Section 7 of this contract provides for the terms and conditions of acceptance of the unit by the purchaser. It states in part, the seller shall notify the purchaser in writing of the readiness of the unit for acceptance by the purchaser and delivery by the seller to the purchaser of the same. My question is, when did Fort Bonifacio Development Corporation notify Mrs. Cristina Corona about the readiness of the unit for acceptance and delivery?
Based on our records of that unit, that the purchaser was notified sometime in the year 2005.
May I pose this question? On or before that date, did the purchaser pay any consideration for the unit?
Usually before we would...
No, I am asking you a pointed question. Did your record show that the buyer, on or before the date you mentioned, the unit was paid for?
Your Honor, based on our records, the unit had been paid for by
so
the time.
it was paid for. The only thing material here is when it was delivered and accepted by the owner.
Yes, Your Honor.
Values had passed from her to the seller.
Based on our record, yes, Your Honor.
All right. Proceed.
So what happened during this inspection for the turnover and delivery of the unit to Mrs. Corona?
Well, as in most turnover processes, there was a punch list executed between the purchaser and the seller, which basically identified the various deficiencies or complaints or things that had to be repaired from the perspective of the purchaser, and this was usually agreed on by the seller, in this case, Fort Bonifacio Development Corporation.
So in other words, there were punch lists containing defects pointed out by the unit purchaser to the developer.
Yes, that's correct.
And what was the action taken by Fort Bonifacio Development Corporation regarding these issues on the construction of the unit, as pointed out by Mrs. Cristina Corona in the punch list?
Well, these punch list items were addressed by FBDC based on whether these were in fact part of the sort of deficiencies created or that appeared because of construction or during construction. Mm-hmm. And we would repair these items as a part of our after-sales service.
And were the repairs actually performed by the developer in this case?
These repairs were, the repairs were prepared over a period of time. Of course, each time we would repair, it would require that the purchaser accept these rectifications.
And Mr. Witness, what was the response of Mrs. Corona to the actions taken by Fort Bonifacio Development Corporation?
The turnover process was somewhat extended, and one of the responses of Mrs. Corona was, while the repairs were being completed, she contested whether she was liable for the payment of association dues to the condominium association.
So did the turnover actually transpire?
There was a conditional turnover sometime in 2006, but nonetheless, when she was assessed condominium dues on that unit, she wrote FBDC that this dues, the assessment from the condominium corporation, should be carried or should be to the account of the developer.
Mr. Witness, before the acceptance by Mrs. Corona of that condominium unit, how much was the total payment for the consideration, the total price of the unit, if you know?
If I may refer to the deed of absolute sale, Your Honor.
What's a deed of absolute sale? Fully paid na yan. The witness, Your Honor, going over the deed of absolute sale, may it be reflected in the record.
Your Honor, the purchase price in the deed of absolute sale was 9,159,940 pesos, Your Honor.
That was the cash out from the pocket of the Coronas to acquire that unit.
Yes, Your Honor, based on our
All right.
records.
So they paid that already
Yes, Your Honor.
to get a unit.
Yes, Your Honor.
Okay. Go ahead, proceed.
Mr. Witness, this response of Mrs. Cristina Corona to Fort Bonifacio Development Corporation for a conditional turnover of the property and a waiver of the association dues, is this response in writing?
Yes, that there was a letter that we received to that effect.
Coming from?
From Mrs. Corona.
If I show to you a copy of this letter, will you be able to identify the same?
I would be able to.
I am showing to you a letter dated January 2, 2006 to Bonifacio Ridge Condominium by one Cristina R. Corona. Is this the letter that you refer to?
Yes, based on our records, this is the letter.
Hindi pa. The prosecutor, Your Honor, is going over the letter. May we request, Mr. Witness, on the second page of this letter, on the bottom portion is the name of Cristina Corona and a signature on top of the name. Would you be able to identify the signature appearing below?
Yes, the signature is consistent with the signature we find on the deed of absolute sale of Mrs. Corona.
Your Honor, just a manifestation. The document presented by the defense is a photocopy.
Never mind. Are you doubting the authenticity of that photocopy?
Well, if the original is in their possession, we would like to see the original.
Do you have a copy of the original of this letter?
I can secure it from our records.
Subject to future presentation, Your Honor.
All right.
May we request, Your Honor, that the letter be marked as our Exhibit 244 and the name and signature of Mrs. Cristina Corona appearing on page 2 be bracketed and marked as our Exhibit 244-A.
May I just clarify another point? If Mrs. Corona did not accept the unit, even though they already paid 9 million plus pesos for it, would there have been a rescission of the contract and a return of the consideration paid for by the Coronas for the unit?
That's a situation, Your Honor, which I'm not familiar we've ever encountered before. But I guess if the contract could not be completed, there would possibly be such a return of the consideration and a return of the unit.
But the fact that at the time that the question regarding the acceptance of the unit was pending resolution, there was already a value paid for by the Coronas for that unit.
That's correct, Your Honor.
All right, proceed.
And so, Mr. Witness, having received this letter from Mrs. Corona, what was the response of Fort Bonifacio Development Corporation?
Well, our response, which was conveyed through our marketing agent, Ayala Land, was that as we rectified the items on the punch list, we would be prepared to shoulder the costs of the association dues for that particular unit.
And was this response reduced in writing?
Yes, it was.
I am showing to you a letter from Ayala Land Incorporated dated September 5, 2006, addressed to a Cristina R. Corona, owner of Unit 1902 Spanish Bay Bonifacio Ridge Condominium. Is this the letter that you refer to?
By the way, Counsel, what is the purpose of this line of questioning?
Your
Are
Honor,
you trying to say that, are you justifying the non-inclusion of the unit as an asset in the SALN of the respondent?
Your Honor, for clarification, the unit was reported in the Statement of Assets, Liabilities, and Net Worth of the Chief Justice in 2010.
And not before?
And not before.
What was reported before with respect to that transaction?
There was no report, Your Honor, with respect to that transaction, and it is our theory that
there was no reported value in the previous end of the Chief Justice with respect to that transaction because the unit was not yet accepted.
Yes, Your Honor. That is the reasoning for the non-inclusion of the purchase at that point in time until 2010, Your Honor.
Yes, but did not the accountant of the Chief Justice consider that value that passed from the family, the Mrs. Corona, to the seller of the unit as a receivable?
Unfortunately, Your Honor, there was no accountant who assisted the Chief Justice at that time, Your Honor. So, to answer the question, it is possible that he was not guided by an accounting expert during this particular time.
I will not press that question. That will be a material consideration. So
yes, Your
proceed.
Honor. Yes, Your Honor. We request that the letter identified by the witness be marked as our Exhibit 245.
With the same manifestation, Your Honor, that the document presented and confronted is a photocopy.
Mr. Witness, the letterhead of this document is Ayala Land Incorporated, and the seller is Fort Bonifacio Development Corporation. Would you know the reason for the disparity?
Yeah, Fort Bonifacio is a very specific development project which is not which is very limited in scope. And Fort Bonifacio basically engaged Ayala Land as its marketing agent in its real estate assets in that development in Bonifacio Global City.
Mr. Witness, in this document, the name of Jocelyn U. Villacruz's Customer Relations Officer appears, and there is a signature on top of the name. Would you be able to recognize whose signature this is?
Yes, this is Joe's signature, and prior to this hearing, I again verified that this was in fact a letter she signed.
Are you familiar with the signature of Mrs. Villacruz?
I am.
And so what happened after this letter was issued by Ayala Land?
Well, again, we continued to address the items on the punch list. But in 2007, again, Mrs. Corona was assessed for association dues for that particular unit. But because of, I think there was a typhoon that hit the country at the time, there were some recurring problems in terms of water leaks, and we had to continue repairing some of those items.
Mr. Counsel, can you not stipulate on this that there was never any reflection of this unit prior to 2010 SAL-N of the Chief Justice, because the unit was not accepted by the family? And I think this is no longer an issue. That's already fully established that there was a refusal to accept it. Cannot the prosecution accept this as a matter of fact?
We're willing to stipulate as to the fact of the non-inclusion of the unit in the SAL-N until 2010.
Because of a dispute regarding its quality. There's already an admission on the part of the defense that value passed from the Coronas to the seller to acquire the property.
If the prosecution, Your Honor, will make the admission, then we will just have the remaining documents marked, Your Honor, subject to the presentation of the originals probably tomorrow.
So that would be the tenor of the rest of his testimony, that there was no acceptance until the year 2010
Yes,
because of defects?
Because of the continuous repair until finally the defects were addressed, and so the turnover was made, and then in 2010 the Chief Justice made the report of the property in SAL-N.
The chair and this court understands the factual situation with respect to this property to be this: that there was a contract to buy a unit, a condominium unit by the Coronas from the what's the name of the seller?
Fort Bonifacio Development Corporation.
Fort Bonifacio Development, on an agreed price of 9 million plus, correct?
Yes, Your Honor.
And then that consideration was paid for. Money was passed from the pocket of the Coronas to the Fort Bonifacio.
Yes, Your Honor.
In exchange for a potential transfer of a unit to the Coronas, which was not accepted prior to 2010.
Yes, Your Honor.
So that is the factual situation. Why can you not stipulate this?
Yes, Your Honor. We would stipulate
so that
that
there will be no more problem about all of this discussion and questions and answers about Jews and so forth and so on. These are irrelevant to this impeachment trial.
We so stipulate, Your Honor. We'd just like to know if there is an actual turnover document which dates the actual transfer to 2010.
The letter of Mrs. Corona was explicit in saying that the turnover was conditional. The condition being the repairs made by the developer. And after the repairs were completed, then Mrs. Corona accepted the unit in full and reported the property in the 2010 SAL-N.
Your Honor, that's the problem. We would be willing to make the stipulation, but there's no document proving that it was indeed accepted in 2010. The letter being referred to is dated 2006.
The witness will actually testify on the point. So the offer of the presiding officer.
Does it matter, counsel, for the prosecution whether the asset involved is a condo or money between those periods? Will it matter?
It will not matter.
All
We will
right.
stipulate, Your Honor.
Come on.
Will the prosecution therefore admit the point that the turnover of the property took place in 2010 and that Mrs. Corona thereafter reported the property in the SALN of December 31, 2010?
If that is the manifestation that would be the testimony of this witness, we would stipulate.
Thank you, Counsel. In which case, to abbreviate, Your Honor, may we request that the Bonifacio Ridge assessment letter for the homeowner's dues dated May 9, 2007 be marked as our Exhibit 246, the response of Mrs. Corona to the said assessment dated August 1, 2007 be marked as our Exhibit 247, the inspection report for Unit B 1902 dated October 7, 2008 executed by Engineer Benedicto Macabenta of the Spanish Bay Bonifacio Ridge Condominium be marked as our Exhibit 248.
Mark them accordingly. Now, may I suggest that both panels will submit a written evidence of your stipulation of fact on this particular property.
Your Honor, we will adopt exactly what will appear in the transcript of stenographic notes that will be provided for us tomorrow.
Yeah. All right. Is that understood, no?
Yes, Your Honor.
We are talking of assets, liabilities, and net worth. Whether the asset is in kind or in cash or in securities or whatnot, tangible or intangible, we are talking of assets. We are talking of liabilities. And we are talking of net worth in the salad. And it's mandated by the Constitution that assets, liabilities, and net worth must be reported, declared under oath. Okay?
With the admissions entered into by the parties with regard to the testimony and documentary evidence identified by this witness, Your Honor, we move that the witness be discharged.
Any objection? The witness is discharged. Next witness.
Your Honor, please, while waiting for the next witness, may we be allowed to make a short manifestation with clarificatory? Thank you, Your Honor. Thank you for allowing us to make the short manifestation, Your Honor, with clarificatory question on the issue of the quashal of the subpoena on Secretary De Lima. Naghain po kami ng motion na i-quash ang subpoena kay Secretary De Lima dahil sa paniwala po namin na delay ang resulta nito. Ayon po mismo sa request for subpoena ng defense, ang lahat ng pwede nilang or gusto nilang itanong kay Secretary De Lima, ayon mismo sa request nila, ay natanong na po. And in fact, they were given all opportunities to ask these questions during the 2 days. 2 days po na nag-cross-examine sila kay Secretary De Lima. Ngayon po, hindi naman namin iniisip na ang depensa ay may iba pang itatanong at minislead ang impeachment court sa tunay na purpose ng pagpatawag nila kay Secretary De Lima. We do not suspect that. Ngayon po, ang sabi namin, ang korte may discretion na i-deny siyempre ang motion o request for subpoena kung tingin ng korte, irrelevant yung testimony, immaterial, o pampahaba lang ng kaso. In fact, may mga subpoena na na-deny ang korte. Katulad nun, may Supreme Court na driver na pumunta dito, willing naman mag-testify. Pero ginrant ng korte ang request ng Supreme Court na hindi sila isubpoena. At may poder ang korte whether or not to grant or to deny the request. Ganon din po sa clerk of court. Willing naman ang clerk of court. In fact, the clerk of court has appeared here previously. Pero ang problema noon, nabulatlat yung salen. So nung na-request ang subpoena niya ng Article 17, hindi na po siya napayagang mag-testify dahil sa sabi ng Korte Suprema, bawal mag-testify sa korteng ito ang mga personnel ng Korte Suprema. Ngayon po, ang tanong po namin ay, nakita po namin kasi itong sulat ni Secretary De Lima at nagsasabi po siya dito na she is, of course, opposing the motion, the subpoena, the request for subpoena of the defense. Pero po may sinabi po siya dito.
What is the date of that letter?
This is May 7 po, 2012. Today po. Sinabi niya po dito, this is, however, without prejudice to the undersigned's continuing sentiment regarding the propriety of her recall to the witness stand, as well as her appeal for her rights to such witness under Section 3. This is for the impeachment court to decide whether or not they will continue with the grant of the subpoena or withdraw it. It's for the court to decide. The court has mentioned in so many times that it wishes to avoid collision with other co-equal branches. However, I'd like to go to the other part of the letter, Your Honor. In line with this, the undersigned respectfully requests clarification on the intended scope of the defense panel's examination of the undersigned, and also whether they intend to treat the undersigned as an unwilling or hostile witness. So ngayon po, ang tanong lang po namin, may nabanggit na po ba ang defense panel kung ano po ang scope ng kanilang examination? Kasi ang sabi po namin sa prosekusyon at sabi rin ni Secretary De Lima, lahat po na yan at testify ko na yan eh. Ano pa ba ang pwede kong sabihin dito? Baka 2 araw na naman po na hindi ko pa nasabi or wala silang oportunidad na matanong nung panahong nag-testify po siya. In fact, hindi mo rin po pwedeng i-claim ni Chief Justice Corona that he is deprived of due process rights. Hindi po. Ang Korte Suprema po, in fact, nung winidhold ang mga witnesses from the Supreme Court, wala talaga kaming opportunity to ask them. Kasi hindi talaga sila pumunta dito. Kami po sa prosekusyon, napresenta si Secretary De Lima, wala po kaming intensyong itago. Walang tinatago si Secretary De Lima. In fact, nag-appear na siya. Ang hiningi lang po ni Secretary De Lima at ng prosekusyon, ano pa po ba ang gagawin at pang-delay na lang ito ang pag-testify niya? Kasi ayon po sa request, these are the same issues discussed. So ang hiningi na lang po namin, baka may gusto pang itanong ang depensa, ang depensa, na hindi nila naitanong o hindi sila pinayagan ng korteng itanong noon, na gusto nilang itanong kay Secretary De Lima, ayon po sa tanong ni Secretary De Lima. I'd like to ask for a clarification on that, Your Honor, if they've answered the question of 1, the intended scope of the defense panel's examination of Secretary De Lima, and also whether they intend to treat the undersigned.
Are you asking for a reconsideration of the ruling of this court?
Well, Your Honor,
I'm asking you.
Yes, Your Honor, if there is a senator who is willing to move for a reconsideration, of course, we would be very happy because that's natural. That is our motion. And secondly, Your Honor...
well, then you ask there's a senator who asked for a reconsideration because I cannot allow a waste of time in discussing this. The chair has already ruled.
Actually, Your Honor...
The proper procedure is, and I understand where you are coming from.
Thank you po.
To ask somebody to make a motion for reconsideration.
Actually po, nasa judgment ng senator, ang hiningi ko lang po, may tanong po, nalinaw na po ba ng depensa?
All right, if the defense wants to explain why they want the Secretary of Justice to come back and be their witness, please say so.
If Your Honor, please, Joel Bodigan for the defense.
Yes, please.
By way of reply, I believe the rules define the proper time for us to make, to manifest to this court the purpose of the testimony that we would elicit from the witness. Not at this time. We are wasting the time of this court by manifestations like this.
All right.
Your Honor, if I may, actually, kung sa manifestation lang lugi kami sa defense, araw-araw, marami silang manifestation. But anyway, Your Honor, ang tingin namin po, yung request for subpoena, hindi ka po pwedeng mag-mislead dyan. Kasi nung nagdesisyon ang impeachment court at ang Senate President for that matter, siyempre tinignan niya po kung may relevance.
I assure you, Mr. Counsel, for the prosecution that this court cannot be misled.
Yes, Your Honor.
We are as intelligent as you are.
That's what I also presume, Your Honor. But they are now saying that they have certain purposes.
It is not
that they did not.
It is not a presumption. We are elected by the Filipino people because they think we are intelligent enough to protect their interests.
Yes, Your Honor. My point being, however, Your Honor, is that meron pala silang mga purpose na hindi nila sinabi dito sa atin. And I'm sure that when the court decided to grant the request, tiningnan nila ang validity, ang relevance, ang materiality ng request. Ngayon po, kung hindi po pala yun ang intensyon nila at may iba pala silang purpose, sana naman na-apprise yung impeachment court para makadecide ng impeachment court kung relevant pa nga ba ang testimony o hindi.
Do you know their intention?
Ang intention po nila nakalagay sa request nila. Ang tanong ko lang po, yun pa ba ang intention nila?
Sinagot ka na eh.
Ang sagot po nila, may intention po silang iba.
The request of the gentleman is denied.
Well, thank you, Your Honor.
Thank
but
you,
we
Your
hope
Honor.
that the clarification later on for the purposes, we will reserve our objection, of course, to any new purpose that they will state during the offer of testimony of Secretary De Lima. Thank you, Your Honor.
Counsel for the defense, call your next witness.
Yes, Your Honor.
Good afternoon, Senate President. Attorney Lichalco, we're calling our next witness, Ms. Annalyn Moises, who is the records keeper of, records officer of the City of Manila. But just to abbreviate the proceedings, Your Honors, if you can make a stipulation, because she's really just being presented to... Well, she's being presented for the purpose of authenticating certain documents as far as the Basa Guidotti transaction.
What are those documents?
Yes, Your Honor. Maybe they can just enumerate, then we can react thereafter.
What are those documents to be authenticated?
Ordinance number 7975, which was pre-marked as Exhibit 227. The deed of sale between the Basa Guidotti Enterprise, Inc. and City of Manila.
I think that is not in issue anymore, a factual issue.
Yes, I mean...
is there any dispute about this?
I don't think so, Your Honor. I don't even think if our good witness here can do any better than that of the good mayor. Because what she may have to testify to today must have been taken up already lengthily by our good mayor. But most especially pertaining to the documents being adverted to.
Your Honor, the previous witness, the counsel for the prosecution was questioning that some documents were Xerox copies. Now we are presenting certified true copies, so it won't be questioned anymore.
Well, if only for the certification of these documents already marked.
What is the point in this authentication? It is already a fact and admitted that there was a transaction between the City of Manila and the Basa Guidotti. In fact, it is also established into the record that money passed from the City of Manila to the seller, Basa Guidotti, represented, according to the presentation of the defense and the government of the City of Manila, that transacted the Basa Guidotti Corporation, and that we have been discussing for days and weeks about 34.7 million consideration for that transaction. What else more is needed to establish that fact?
So, Your Honor, if they're willing to admit that there exists a ordinance authorizing the supposed purchase and supposedly there is a absolute deed of sale.
If there is a defect in the sale, it's impertinent, immaterial, irrelevant in this proceeding.
Okay, Your Honor. So,
go ahead.
Which case, Your Honor, then if there is no issue at all, then we can call our next witness.
Yeah, call
And
your
discharge.
next,
Your Honor,
call your next witness.
Thank you.
We'd like to call Miss Efleda Castro. She is the Manila Market Administrator.
May we just know the purpose or purposes she's being
So
offered?
that the City of Manila is in possession. They are deriving income therefrom.
There's no question
There is
about
no
that.
question
Already
on that.
has been solved.
You can stipulate on those.
What is the
on these two
materiality of
particular aspects?
just a minute? What's the materiality of this kind of evidence in this impeachment trial?
Your Honor, because they may be questioning the transfer of ownership, the turnover, and who is actually
That
in
is
possession.
immaterial to this court, whether the property was transferred or not. There was a transaction, whether that is void, immaterial, there is a transaction, money passed from the City of Manila to Mrs. Cristina Corona.
Okay. So they stipulate, Your Honor. No problem.
We agree on the observation of the presiding officer. If only as to question of possession, there will be no quarrel with us.
Okay.
But as to other purposes,
You
we
know,
agree
we
that
are-
they are immaterial. Your
What I'm trying to avoid is we're cluttering this proceeding with so many collateral, irrelevant, immaterial issues.
So sino next witness?
We're wasting time.
Who's next witness? Meron pa tayo?
Please go direct to the point so that we can finish this case. Present the defense of the respondent.
Your Honor, we have other witnesses who are supposed to have been scheduled for tomorrow. They arrived earlier. If you would give us a short break, I will check if they're still available, and I will present more
Session
witnesses.
suspended for
10 to 15 minutes, Your Honor.
15 minutes.
Thank you very much.
Okay, pag-usapan na natin yung controversial na condo unit.
Oo nga,
Kanina-
kasama pa rin natin si Dean Pangalangan, syempre, ng
Oh,
UP.
kanina habang nagdi-discuss yun ang tanong natin. Matagal na hong debate yun, di ba? Bago nag-break itong impeachment court na ito. Nagbayad na, pero wala pa ho yung tinatawag na na-delay yung transfer o
Dahil may mga depekto raw, kaya
Renovation,
hindi pa siguro natatanggap yung deed of acceptance. Does that mean na justified sila in not including it in the SALN?
yung declaration nun.
Well, sa akin, I'll give you both sides theories. On the part of the defense, ang linya nila, they refused acceptance. Kaya nga yung testigo kanina from, I think, the Fort Bonifacio,
Yes.
Si Mr. Quintana.
developer said, on the day itself, dinala nila doon yung buyer, pinakita yung unit, at maraming tanong yung buyer. So, on the part of the defense, sila ngayon nagpepresenta ng ebidensya, ang teorya nila is that there was no proper delivery of the unit, and therefore until they accept it, until it was delivered, it was they had no obligation to list it, to report it in the SALN. Kaya nga, if you recall, ang tanong daw, sino ang magbabayad ng association dues habang nire-repair pa? Kasi para sa kanila, hindi nyo pa yan na-deliver sa amin, hindi pa namin magagamit, bakit naman kami magbabayad ng association dues? So that is on on their side. On the part of the prosecution, this is a point which was raised a long time ago.
Oo nga po.
Pwede ba mangyari, ang tanong ni Senator Enrile, ang sabi niya is that at any moment, yung perang binayad para sa yung kayamanan na iniluwal para doon sa property, at any moment that wealth has to be reported in the SALN.
Yes.
Tama naman. Sabi niya, pwede mong i-report yan as money in the bank. Pero kung binayad mo na, dapat i-report mo yan as an asset. Yung pera, naging condominium na. Hindi pwedeng at there is a point in time na biglang naging hangin na lang yung kayamanan na yon.
Invisible.
Na naging invisible, that's correct. Winidraw sa bangko, binayad, tapos dahil nung binayad sa developer, sabi, ayaw namin tanggapin yung unit, hindi ni-report kahit saan. Kaya nga, I think it was Senator Osmeña who said, di sana man lang ni-report nyo yan as an account receivable. Kasi nga, winidraw na sa bangko, so hindi na siya cash. Binayad para sa condominium, pero ayaw tanggapin, so hindi naman, ayaw nila i-report as real estate. Pero ang sagot ni Senator Osmeña, report it as an account receivable. But, and going back to the point of Enrile, at no point in time can it suddenly become invisible in the SALN. So those are the two sides of the argument. I would say that...
Ano ba nasa batas?
Okay. It is the moment of delivery.
Yung ownership?
Yes. The transaction is consummated. Kasi there is the moment of perfection. When the contract is, when the parties agree to the terms of the contract and that the obligations contained in the contract are mutually enforceable. No, it's not just a condition. The moment
completion, na-kompleto na yung proseso.
That's correct, yes.
Dahil na-deliver na po.
Yes, delivery is the moment of completion. So, kaya nga, they were relying on that parang the twilight zone. Fully paid pero ayaw nila tanggapin. Sa akin, ang weakness to argumento na yon, napakatagal naman nung delay.
Kasi 2008 ata binili, tapos 2010 pa lang
yes,
pinangga.
Parang
2 years.
So yes, that mean 2 years siya dapat mawala sa SALN at sa 2010 lang
that is correct. That was actually raised by several of the senators. Para bang siguro kung may delay, pwedeng kung ilang buwan siguro.
Hindi kaya lugi-lugi na yung bumili. Dapat may discount na yon. o kaya nagbabayad ba sila ng monthly? Kasi di ba sa mga condominium may monthly dues yan eh.
Yes,
Pag hindi ba na-deliver, may binabayaran ba sila?
Kaya nga yun daw ang ni-raise ni...
Kung sa security fees, binabantayan pa rin yung unit. Hindi ba?
Yes. So I suppose yun ang... katulad nung pinaliwanag kanina, those are the points they will like to... arguments they will make in their memorandum. Kasi ngayon, presentation of evidence eh. Yun na yung mga... diskusyon.
Pero ang problema, kunyari, mukhang napakatagal naman bago ma-deliver. Hindi ba pag sinabi ng developer, ganun talaga eh, parang pagdududahan pa ba natin yon? Yung sinasabi ng developer na, ganun talaga yung panahon na naisaayos yung condo unit.
Yeah, maraming pina-repair. Marami daw reklamo.
Pag dumating, sinasabi sila.
But when it comes to the impeachment trial, I guess ang relevant lang talaga dito is how that asset was recorded in the SALN, no? Kesa may depekto siya or what. I guess what's important is that if you spend 10 million on a property, that 10 million has to show up in your SALN as something, cash, receivable, asset purchased, whatever, but it has to show up in the SALN somehow. Now, ang sinasabi nitong abogado ng depensa, there was no accountant to assist the Chief Justice when he made the SALN, which is why maybe he may have omitted certain details. Is that acceptable?
Well, it's a matter of judgment, okay? Just my opinion. Una-una, pirma niya yung nasa babae. I mean, he signed the document. He has to be ultimately responsible.
Check pa rin niya yun.
Yes. The fact that whether he was assisted or not, I think it can help explain some omissions, some mistakes. And I think for the this is just my opinion, for the Filipino public, I think we can understand kung may mga mali kung walang tumulong. Pero sa akin, there are some mistakes which cannot be explained away by the fact that there was no
accountant.
Yeah, no accountant. Katulad dito, sa akin, napakalinaw naman, medyo malaki-laki yung chunk of money na parang sabihin na hindi nila ire-report. Sa akin, dapat naman magdalawang isip din na kung hindi nila ire-report, sana naman, yun nga, katulad ng pinaliwanag kanina, don't report it as real estate, but you can report it as an account receiver.
Kung yung accountant niya, yun pa rin sa maraming taon, imposible hindi niya makita yung mga discrepancies at magtanong na rin siya kay Chief Justice Corona, di ba?
Yes, parang...
kasi responsibility
pero wala raw accountant sabi, di ba?
Ng ilang taon.
Yeah, but in the scenario that you describe, Arnold, the scenario assumes na may parang regular na accountant na kausap.
Dapat.
At siya na yung makakapansin na, uy sir, meron ditong kulang
Nadeklaran nyo last year, ba't ngayon
yes.
Diba?
Well,
hindi sinabi sinasadya, pero pinapaalala din
yung makakatulong, definitely. Makakatulong doon yung accountant.
Lalo na ngayon, nag-file na naman nung last April, di ba?
April 30.
Na mga SALN, yung mga government employees and officials. Yes. Naiba kaya yung kanilang mga statement dahil sa nangyari?
Ay, accountant na siguro ngayon.
Diba? Kasi inamin naman lang, may mga konting revisions. Although hindi napatupad yung mahigpit na form ng SALN ngayon.
Sinuspend yung bagong form. Pero I'm pretty sure, sineryoso na yung SALN after this...
Pero alam mo, Dean, may usapan pa rin, ano ba idedeklara kung acquisition cost o yung fair market value dahil kung acquisition cost at hindi ko naman binebenta, dililitaw nga tumaas yung asset ko kahit hindi ko ina-unload yung pera, di ba? Pero yung pala, kailangan pa rin na ideklara yung acquisition cost at fair market value, tama ba?
As far as I know, may dalawang column. But as I have... it has been my position from the beginning that it should be acquisition cost. Kasi ang tanong na naman, ill-gotten wealth.
Yes,
so how much did you get it for? Kasi
magkano yung lumabas sa bulsa mo?
Magkano yung lumabas? Ko-compare yun sa legal, sa legitimate income. In fact, yung fair market value is actually speculative until the moment comes. I mean, you can compare it. I mean, there are professional real property appraisers.
Pero minsan may palusot kasi, ba't kayo yumaman? Fair market value kasi nito. Di ba? May mga government
kaya nga dapat acquisition value na lang.
Kunyari, dumoble yung SALN. Bakit? Kasi nagkaroon ng sa fair market value. Nagkaroon ng condominium dito, real estate dito. Tumaas daw yung value ng lote.
Yes.
Pero for purposes of establishing ill-gotten wealth, it's really acquisition value. Kasi yung pera na lumabas sa'yo, yun ang pera na binayad sa'yo. So, dapat acquisition.
Yes. In fact, going back to Arnold's point, yung fair market value is affected by so many factors. Kung may magtayo ng bagong mall sa tabi, kung may bagong kalsada na ginawa, kung may
bagyo.
Kung mapasama ka sa listahan ng earthquake fault, bababa yun.
Exactly.
Kung nagbabago-bago
Kung naundoy. So, these are all parang speculative matters na mahirap na i-capture sa isang dokumento.
Okay. Yung pagharap po ni Secretary De Lima, naging issue na naman ngayon, kasi di ba may mga witnesses yung prosecution na minsan ina-accept na naman as witness din po ng defense. Pero dito sa kaso ni Secretary De Lima, parang siya na mismo ang tumangging bumalik uli dito sa impeachment court.
Well, that's right. Nag-testify na siya.
Opo.
At kung tatanungin siya ulit about exactly that same point, katulad na sabi ni Congressman Colmenares, sayang naman ang panahon ng husgado. Pero yun na nga, may ruling na si Senator Enrile. So the subpoena stands.
Okay, samantala tuloy-tuloy pa rin ang ating balitaan. Babalikan natin si Dean mamaya dito po sa GMA News TV.
Ang News TV Live ihahatid sa inyo ni Trisha Zafra.
Salamat Arnold at Vicky. Lilipat na sa kanyang mansyon sa Maynila sa Miyerkules si dating Pangulong Joseph Estrada. Sinimulan na raw ng pamilya Ligarda ang paghahakot para hindi maantala ang paglilipat ni Erap. Mismong si Erap ang kumumpirma ng kanyang paglipat. Sasakay daw siya sa jeep ni Erap na siya mismo ang magmamaneho at pasahero naman niya ang vice-alkalde ng Maynila na si Isko Moreno. Alinsunod sa batas, kailangan ng 1-year residency ang isang tao na nais kumandidato para sa lokal na posisyon. Sa kabila nito, wala pang tiyak na desisyon si Erap kung tatakbo nga ba siya sa pagka-mayor ng Maynila. Samantala, hindi raw makakaapekto ang pagkamatay ni Alfred Mendiola sa mga carnapping case kung saan tumayo siyang star witness. Natagpo ang patay sa isang bakanting lote sa Dasmariñas, Cavite si Mendiola na pangunahing testigo laban sa carnap suspects na sina Raymond at Roger Dominguez. Bukod kay Mendiola, 2 iba pang bangkay ang natagpo ang nakagapos, nakapiring at may tama ng bala sa ulo. Ayon kay Justice Secretary Leila de Lima, tapos na naman ang testimonya ni Mendiola. Gaya raw sa normal proceedings, i-adapt na lang daw ng prosekusyon ang testimony ni Mendiola nang humarap siya para sa bail hearing. Kaya wala raw magiging problema sa pagpapatuloy ng mga pagdinig. At yan po ang iba pang malalaking balita sa oras na ito. Para sa News TV Live, ako si Tricia Zafra. Balik sa inyo, Arnold at Vicky.
Maraming salamat sa iyo, Tricia Zafra. At ngayon, balik po tayo sa ating talakayan. Kasama rin po si Dean Raul Pangalangan, dating dekano ng UP College of Law.
Okay, sa takbo po ng mga discussion ngayon, yung mga 3 weeks no, na natitira na lamang dito sa impeachment bago yung sasara ng sesyon ng Kongreso. Aabot ba sila na magkaroon ng desisyon? Kasi tumayo si Senator Miriam Santiago rin po kanina. Are they bound by law na tapusin ito agad or after ng congressional tutuloy na naman?
Yes, well, Senator Miriam raises a very important point. Can the court actually terminate the trial even if the parties still want to present more evidence? Sa akin ganito, as a matter of fairness and due process, the parties should have the flexibility to develop their case according to their needs. That was affirmed actually by Senator Enrile earlier. But Senator Enrile also showed earlier he would cut short the parties if he feels they were wasting the court's time. For me, the court has a lot. It's not like a black and white scenario, the way it was painted by Senator Santiago, saying you stop the trial now. What the court has the power to do is to pressure them the way they were pressured today. To be told, look, this witness is superfluous. Kahit naman anong testimony nito, pareho din doon sa sinabi dati ni Mayor Atienza, like if you notice earlier. So that is the latitude of the court. But the countervailing interest is that pag nasobrahan naman, baka sabihin naman nung party uy, may right to due process kami dito bigyan nyo lang kami yung pagkakataon to prove our case. Yun ang pinakamalakas na argumento. But if you look at the larger picture, yes, the court will have a lot of ways to expedite the proceedings the way Senator Enrile was doing, but if it is overdone, the parties can...
Hindi naman yung hanggang alas 10 sila, no? O kaya midnight.
Magpa-prosper kaya ho yun yung proposal na yun?
Yung depensa talagang ang kanila inaalala si lead prosecutor, no? Cuevas.
Well, I'm hoping na...
2 to 12.
Ako, mukha namang hindi realistic.
Ang suggestion ay galing pa sa isang 88-year-old. Kaya parang wala silang masabi, no?
Yes, well, yes, I sure hope. I looked at the dates. They say that this session will
June 7.
June 7.
Opo.
Under the Constitution, they can actually extend to June, roughly around June 18, 19.
Pwede pa ba ho yun?
Well, kasi the constitutional rule is that it should be 30 working days before the SONA. The SONA technically is the fourth Monday of the last Monday of July. Which is July the 30th. So we have to work backwards. I haven't done the exact math, but it should be roughly the week of June 18 or
before SONA
19.
Para maganda yung paksa ng SONA.
Yes. I think realistically for all parties concerned,
tama po.
They would need a decision by the State of the Nation address. Okay. Otherwise, sila nasisitahin ng bayan.
Ng publiko.
Whether it is the prosecution causing the defense or the delay or the defense causing the delay.
Dami na nga hong issue na wala pang congressional hearings ngayon, no?
Oo
At yun ang nirereklamo rin ng publiko.
Ang legislative work ng Senate naantala dahil nga dito sa impeachment.
Update yata tayo,
At ngayon,
Vicky.
balikan po natin si Joseph Morong sa Senado. Joseph! Mukhang pinapabilis na ang proseso ng impeachment. Mukhang talagang pinapast
Ramdam mo ba?
na. Oo.
Si Senate Presiding Officer Enrile, kung dati parang pinapayagan pa niya, medyo lenient pa. Kung halimbawa, yung isang testigo ay medyo uulitin lamang yung tinestify ng isa pang testigo, pinapayagan before. But now, it's very different. Kahit siya, medyo naiinip na. Minsan nga, siya na yung nagtatanong doon sa mga testigo or doon sa counsel, either the prosecution or the defense, ano bang point? Tapos pag sinabi na yung point, dapat hindi pa yun yung tumbukin. So, ngayon lang natin nakikita at nagiging pronounce yung ganyang attack nitong CSP Enrile. Kasi nga, gusto rin siguro na lang matapos yung kanina sa ambush interview sa kanya pagkatapos ng caucus, ay they will try to finish daw by May 30. So, ang sabi kanina na Attorney Jimeno, before tayo pumasok sa loob to cover, ay mga 12. Tapos may iba nagsasabi 16. So, pagpalagay natin ng 12 to 16. And we're down now with 5 witnesses. So, at least 11 na lamang yan. And judging from the demeanor of the senators ngayon, ay talagang kung nakikita nila na wala ng, kumbaga, pandagdag na lang na kwento yan at nasabi na yan before, makang babarahin na lang naman nila yan at ididiretso na dun sa punto na ngayon. Ngayon, doon sa posibilidad na mag-extend tayo hanggang alas 10, wala pang ruling, yung ating Senate Impeachment Court dyan. Ang nakakausap natin ng mga staff ng ilang senador ay mukhang ang inclination nila is that at the very least or at most ay 7 o'clock ng gabi. Hindi naman yan first time na mangyari kasi meron na tayong naranasan na 1 or 2 days na natapos tayo ng 7 o'clock. Ang hindi pa lang natin na alam ngayon from the defense ay kung meron pa sila na ipipresenta for today. Kasi nung bago magsimula yung trial ngayong umaga, ay kaninang hapon, ay ang sabi sa atin ay meron silang 5. Natapos na yan. Anong oras pa lamang? Wala pang alas 5. So, hintayin natin ang response ng defense kung meron pa silang idadagdag na mga testigo. So far, ang nakinig natin ay yung mga testimonies tungkol doon sa circumstances ng pagbili ng Manila City Government doon sa properties ng BGI, Basa Gilote Enterprises, for 34.1 million. Whether that is legal or may konting problema doon, ang sabi ng Senate Impeachment Court ay that it's immaterial. Basta ang concern ng Senate is that bumili ang Manila City Government for 34.1 or 0.7 million ng property galing sa BGI. At yung pera ay entrust umano dito kay Mrs. Corona. Igan, Vicky.
Joseph, sino bang hinihintay natin ngayon na testigo?
Doon sa ibinigay kasi na lineup sa atin for today, 5, ubos na yan eh. So kanina nga ang sabi nitong si Attorney Jude Roy ay they will confer kung andyan pa yung iba nilang testigo. But as far as yung una nilang batch of witnesses ay ubos na yung 5 na yan. Tingnan natin kung meron pa mga naka-standby sila aside from the 5 witnesses that they already presented. Titingnan natin kung meron pa, di siguro 1 or 2. Tapos siguro tayo ng alas 6 or alas 7 unless the Senate says, no, we're willing to finish this until mga 10 o'clock. So we will find out later dun sa response ng defense. Anyway, sinabi naman ni Attorney Jude Roy na tatanungin niya.
Pero Joseph, itong testigong hinihintay natin dyan sa Senado, ay nandyan pa sila physically or ire-recall pa sila, manggagaling pa sila sa kanilang mga bahay o opisina?
Ang sabi ni Attorney Jude Roy ay naka-standby doon sa kanilang holding room kasi Vicky, may mga holding rooms yung prosecution and defense. At ang sinasabi nila before, bago tayo mag-break noong March 22, ay mga naka-standby nila 10. Kumbaga sa bala yan, naka-prepare, 10 tayo. So titingnan pa nila kung yung 5 or 5 others ay hindi pa nakakauwi. At kung hindi pa nakakauwi, ididiretso na yan. At depende na lamang dun sa tinatawag na materiality kung tatagal ba yung pagtestigo nila before the Senate Impeachment Court.
Hindi siguro nila inaasahan na ganitong kabilis ang magiging pace ng impeachment proceeding sa araw na ito.
Yeah, tinanong natin sila if they minded. Kasi kung ikaw, testigo mo yun, tapos binabari lang, hindi na natin kailangan yan, next sa kanilang kaso. Ang sabi nila, Attorney Jude Roy, ay hindi naman daw. Kasi nga, ang point lamang noong 4 witnesses at least, aside from former Manila Mayor Atienza, ay established lamang na may pumasok na pera, may ibinigay na pera, yung Manila City Government kay Mrs. Corona na 34.7 million in 2001.
Okay.
Joseph.
Ewan ko lang kung kamusta na yung salin ng mga senador, kompleto na.
May nagbigay sa amin na isa. No?
Kita mo. Kasi maano ngayon ang salin na issue.
Oo. May nagbigay ng isa. We will discuss with the office kung
sige.
Kasi
inaabangan ko rin yun.
33.
Ilan ba yun? 23 sila ngayon, no?
3 at least.
Pero yung mga prosecutor, lumabas na yung mga salin nila, no?
Di lahat.
Si Nery Colmenares ang pinakamababang net worth. Joseph, paano ba nila mareresolve itong issue kung talagang papayagan ba nito itong extension hanggang 10 p.m. or 12 midnight? Botohan ba yan? Paano pa?
Actually, ang direction or decision is upon the Senate. So kung sabihin ni SP Enrile, ay gusto ko hanggang alas 12 ng madaling araw, wala tayong magagawa. Even if the defense objects to it.
Kaya mo magreklamo pa yung mga bata.
Kami medyo hindi rin
Kaya natin yan.
Para diretsong saksi na, di ba?
Ayun nga, live na live.
Tatawid lang kami. Okay, maraming salamat, Joseph. At live po siya ngayon dyan po sa impeachment court. Ayan, nakita natin ilang mga senador pa naghintay. 10 to 15 minutes po hiningi na
extension.
Recess nitong impeachment court dahil doon nga sa kanilang 5 witness dapat ngayong araw na ito naubos.
Nasaid na kaya ngayon naghihintay sila ng iba pang karagdagang witness.
Okay, balikan natin ang ating talakayan kasama si Dean Raul Pangalangan. Yung 1 month bang recess would be may epekto ba dun sa interest ng publiko o maging dito na rin sa dalawang panel na ito, yung defense saka prosecution, medyo ba parang tinamad o...
Yung nakaraan pong...
Kasi kahit 1 month suspended naman yan, tuloy naman ng di ba? Mga issues pa rin
Yung itong nakaraang...
Yes.
Ako naman, I think it was good for everyone.
Sinundan nyo pa rin din kahit wala yung 1 month?
I'm sorry?
Sinundan nyo pa rin, kunyari, 1 month di ba? Wala namang...
Ako naman, I also took a break from from all these discussions. In fact, ang major development lang yung nangyari sa Ombudsman.
Yes, 10 million.
Yes, that is the only new development. Apart from that, it was basically the parties issuing statements every now and then. So I think in terms of the public interest, I think my personal opinion is mabuti nagkaroon ng break. Otherwise, I think we were reaching a point of saturation already in terms of public patience.
Doon sa presentation ba ng mga witness and evidence ng depensa, ano ba tawag dito? Nangingibabaw ba ito sa naging presentasyon naman ng prosecution? Kasi hanggang sa ngayon parang hindi ko pa rin makikitang nasagot yung mga basic question dito kay CJ Corona. Like yung sa mga bank account, yung withdraw, bago mag-impeachment, dineposit din pala sa hiwalay na account, pero same bank. Nasasagot ba para kahit pa paano malinis pa rin yung kanyang pangalan?
We have to go back to one of the very first points raised by Senator Gringo Anasan. Sabi niya, does the presumption of innocence apply?
Okay.
All the parties agreed, yes, it applies in the impeachment proceedings. Ang effect on Arnold is that, exactly as you say, the burden this time I'm saying it, the burden lies on the prosecution to prove its case. And as you say, you suggest now, the issue is whether the defense so far has cast enough doubt in the version given by the prosecution. Sa akin, and this is a point I've been wondering about the whole time. Ang depensa, the way they prove that all the wealth was properly acquired is to show all the money that was properly, legally paid to Chief Justice Corona. Kaya pinresenta nila yung payroll officer ng Supreme Court, yung the payroll officer of Malacanang when he was still working there, para ipakita lahat itong milyon-milyon na kinita, kung itapat mo naman sa milyon-milyon na binili, pwedeng nagmamatch. Sa akin lang, this is money earned over several years. And even if they match, I'm just wondering, I mean, surely he needed money for his day-to-day expenses between now and then. Even if they
So dapat nabawasan pa rin.
Yeah, nabawasan pa rin eh.
Oo.
So what they would have to prove is that there was legally acquired money over and above.
Yun yung punto ni
actual
Senator
cost.
Bongbong Marcos eh. Nakita
Yes.
ko, di ba? Para bang tinanong niya ano ba daily expenses.
Yes.
At may isang senador din na nagkaroon ng ganung uri ng discussion.
Yes.
Tapos si Senator Trillanes rin yata yan, no? Naging practical din yung tanong niya na kung ibabawas nga ito, ano yung pambayad niya ng kuryente? Siya niya kinuha. Pambayad dun sa staff niya, ay mga katulong, di ba?
Yes.
At pambayad ng tubig. Parang may extra money siyang ano.
Yes.
At hindi pa na-factor in dito yung dollar accounts, yung alleged dollar accounts, which have been concealed until now, no?
That is correct. Kaya lang given the earlier rulings of the impeachment court and the Supreme Court, hindi naaabot doon yung usapan kasi hindi pwede buksan yung mga
Pero
yung mga dollar
paano
accounts.
sinasabi nga ni Chief Justice Artemio Panganiban, no, sa kanyang column kahapon, mismo si Chief Justice nagsabi, in due time.
Yes.
Ilalabas siya. Kahit sa interview ko sa kanya, di ba? Sinasabi niya, sa panahon, Arnold, ipapaliwanag ko na walang ilgatin o hindi sobra-sobra sa yaman yung pinapalabas nila. 3 weeks na lang tayo bago mag-June 7. Kailan pa kaya yung in due time? Wala tayong makitang interest din sa part ng depensa na ipapatestify nila si Chief Justice Corona dahil may fear na baka nandun yung mapastos yata, yung pamilya.
Yes.
Although ina-assure naman ng prosecution na hindi magiging gano'n dahil may mga umatin naman dyan na witness na very civil yung civil yung kanilang pagtatanong. So, i-hold pa ba natin yung pangako ni CJ na in due time, no?
Baka naman ang paliwanag niya is that, ipapaliwanag ko, pero hindi dyan sa husgado.
Hindi sa court.
Yes. Baka dapat interviewin mo siya ulit. Ipaalala mo sa kanya yung pangako. And,
kasi sabi niya, bubuksan ko yan at papatunayan ko. Di ba yun ang
Yes.
kanyang matigas na paninindigan eh?
Yes. So, in fact, yun ang pwede niyang lusot na papaliwanag niya pero hindi sa impeachment court. Kaya nga sa akin, the effect of the proceedings before the Ombudsman, the importance is less legal and more political. In the sense that it reminds people about the concealed dollar accounts. It reminds people about the promise that he made before you on live TV. In other words, it puts him on the defensive.
Hindi niya pwedeng tanggihan ng ombudsman sa hiningi explanation sa kanya.
Well, before the ombudsman, the problem still remains that the
impeachment.
No, that the Supreme Court has upheld the confidentiality of these documents. It depends on how he will draft his reply. Although I read in one newspaper he has actually drafted a reply, just making a blanket denial, but that's just a newspaper account.
Is that enough, a blanket denial from the Supreme Court,
Well,
Chief Justice?
I have not. I'm assuming that it wasn't a blanket denial about having a dollar account. It was a blanket denial saying, I will assume that the complainant, because there were private complainants before the ombudsman, have not presented any proof, and therefore there is nothing for me to disprove. I'm just assuming that based on the newspaper article.
Bukod doon sa in due time, isa pa ho sa naiwan nating issue during the break, yung issue ng Hacienda Luisita. Yun yung sinasabi niyang depensa na iniipit siya ng Pangulong Noy dahil nga sa Hacienda Luisita. Pero nagbigay na po ng final decision with finality nga.
Yes.
So, maubusan na rin siya ng depensa ba dito sa pagsasampa ng impeachment sa kanya?
Well, definitely. Now that you raise that, Arnold, to start with, the Hacienda Luisita explanation for me does not really wash. For me, I think the last straw was the TRO on the watch list order on Arroyo. Kasi kung nakalampas si Arroyo doon sa airport nung gabing yun, tapos na. So for me, that was a trigger for the case. But now that you raise that, Arnold, yes indeed.
Naubusan na siya ng depensa, di ba?
Parang ang sinasabi niya, pine-pressure siya para sa kasong ito. And ngayon, tapos na. Resolve na yung motion for reconsideration.
At same issue pa rin itong kinakaharap niya.
Yes.
And that's final. Hindi na pwede mag-flip-flop doon sa desisyon tungkol sa Hacienda
I
Lucita.
sure hope not. Yeah, it should be. It should be final, yes.
Final. Hindi na pwedeng appeal or...
Wala ba tayong magiging problema nga dun sa, balikan ko lang sa ombudsman, kung mauna silang magdesisyon kaya sa impeachment? Pwede ba mangyari yun?
Well, okay. Ang dedesisyonan ng ombudsman is whether to file, whether there is
Kung may probable cause.
Yes, kung may probable cause. But it will still have to be filed as an impeachment case.
Next year na dahil may 1 year tayo ban, tama ba?
That is correct, yes. But as I've said,
impeachment na naman.
even as a even before the ombudsman, the Supreme Court's ruling on confidentiality is still there.
And there's no chance that they're gonna rule on it before the impeachment is over. I think sa June pa ata nila balak ilabas ang kanilang findings tungkol doon, ano?
For the ombudsman.
No, I'm sorry. The TRO issued by the Supreme Court on the dollar accounts.
Yes, I will assume. In fact, I am assuming that they, even when they finally decide, they will uphold the confidentiality, because independent of this case, I think there are larger considerations for the banking community. So this is at the level of, I would say, of the legislative policy that underlies the confidentiality of foreign currency deposits.
Sa development ho ba ngayon din, beyond politics na ho ba nakikita natin ngayon? Talagang may dapat ng panagutan si CJ Corona?
Well, when you say beyond politics...
Kasi di ba dati, pinupolitika lang ako, di ba? Parang gano'n dahil kakampi niya si dating Pangulong GMA. Pero with this development na valid pala yung mga tinatanong sa kanya, no? Na kailangang isagot niya sa bayan, na medyo natasantabi na ba yung politics? Kasi yun din ang depensa nung kabila, di ba, na napupolitika siya. All resources of the government laban sa kanya.
Yes.
Kailangan mawala siya sa Supreme Court. Hadlang siya sa kampanya ng tuwid na daan, di ba? So ngayon ba medyo naano na yung political undertone nito at doon na tayo sa mga issues concerned?
Well, it brings us back to your point that until now he refuses to testify.
Yung pa rin.
The very first procedural ruling by I think the second procedural ruling by the impeachment court was a ruling upholding his right against self-incrimination, and also upholding the privilege not to testify invoked by his family. So if it's a question of whether he can refuse to testify, he can. But I think we are beyond that point. Ngayon, ang tanong na, exactly the way you raise it, Arnold, is kung hanggang ngayon, ayaw pa rin niyang humarap, I think it sort of undermines the credibility of his
Parang
defense.
nasa court of public opinion na siya.
Yes, at saka exactly as you reminded him a while back, nangako siya that he will come clean and make a clean breast of the allegations of ill-gotten wealth against him. So, in fact, that should be the effect of the proceedings before the ombudsman.
Now, I want to go back to the $10 million issue na iniharap ng ombudsman, no? They feel, at least Corona's camp feels, na walang jurisdiction ng ombudsman dito, so they can either ignore it or they can bring it up to the Supreme Court. You think they're going to do that?
Bago nyo sagutin din, balikan muna natin yung impeachment.
Okay.
Four witnesses who are prepared to take the stand, may I request that we be allowed to present them tomorrow? We did, after all, manage to go through 5 witnesses.
How many witnesses does the defense wish to present to defend the Chief Justice?
Your Honor, we had originally about 14, but we have trimmed that list down considering your public announcements that you would like to finish the trial sooner. As a result of which, I believe we'll be down to about 5 or 6 witnesses, Your Honor.
Actually, we narrowed down already the number of articles of impeachment to be considered. And as far as Article 7, Article 3 are concerned, these are matter of public record. No? So the only material matter that will require the presentation of evidence will be Article 2.
Precisely, Your Honor. And if I'm not mistaken, the remaining witnesses all pertain to issues pertaining to Article 2.
Precisely.
Except for the subpoena issued to the good Secretary of Justice, Mr. President.
Well,
Mr. President.
The court will not anticipate how the defense will defend the respondent, Chief Justice.
Thank you, Mr. President.
But I hope you understand that the Senate cannot afford also to prolong this case because the legislative agenda of the nation is affected.
To be sure, Mr. President, you have our assurance that we do not wish to burden the Senate by delaying it in any way.
It's not a burden to us. It's
Thank
a
you,
burden
Mr.
to the
President.
nation.
May I then manifest, in accordance with the letter that we received today from the good Secretary, that we would require her attendance on Wednesday, if that is possible.
No, you have to make an arrangement with her. She's your witness.
Yes, Your Honor. We are
So you
informing
make
the
an
court.
arrangement with her when she's to come here.
Yes, Your Honor. We are informing the court because the letter that we received today was not yet taken up in the business that we tackled this morning. So we will make that arrangement, Your Honor.
All right. So you're asking for a continuance?
Yes, Your Honor.
About the prosecution?
Yes. Go ahead.
Mr. President, we have no objection to the pleasure by the defense. We have no objection. We just want to ask Mr. President if the defense is willing to name the 5 or 6 witnesses that they are going to present.
Mr. President, may we recognize Senator Jingoy Estrada to make a manifestation and pose an interjection on the question of the prosecution.
Thank you.
Mr.
If I may, Mr. President. Mr. Consul, instead of cluttering this court, to borrow the words of the Senate President, instead of cluttering this court with witnesses who are impertinent, immaterial, or irrelevant to these proceedings, I suggest that you bring the respondent himself to answer all the allegations leveled against him. And if the Chief Justice will appear, the judges, the impeachment court will be very, very happy to hear his side. At doon pa lang, pagka marinig na namin ang side ni Chief Justice tungkol sa mga allegation nila, doon pa lang siguro makakapagbuo na kami ng desisyon kung ano ang didesisyon namin. Just to give you a classic example, during the impeachment case of former President Estrada was waiting to be summoned by this impeachment court. He was daring to appear before this impeachment court dahil according to him, wala siyang tinatago. Ngayon, kung talagang walang tinatago si Chief Justice Corona, bakit hindi lang siya ang dalhin niyo rito para siya mismo ang sumagot sa lahat ng mga alegasyon nitong prosecution panel laban kay Chief Justice Corona? Pati yung 10 milyon na naiulat, nailathala sa dyaryo, sagutin na rin niya kung talagang totoong meron $10 million dun sa bangko ni Chief Justice. Para kung sa gayon, matapos na kagad itong impeachment trial at makapag-render na ng desisyon kagad. Hindi yung katulad ng mga witnesses na pre-presenta nyo dito. Hindi naman kailangan. Pwede naman i-stipulate ng prosecution panel yan. You are just wasting the time of this court. Mr. Consul, if I may, ako ayoko makialam kung i-presenta yung Chief Justice. Pero sa amin, mas makakabuti, and I reiterate yung mga sinabi ng mga kapwa ko senador, na dalhin nyo na si Chief Justice dito i-presenta nyo na siya rito para malaman na namin kung ano talagang buong katotohanan niya yung mga yan.
Well, thank you for that admonition, Mr. Senator. But this is an impeachment proceedings. and notwithstanding the character of the proceedings, Your Honor, due process should still be. What are the charges against him? That he had amassed properties which he did not declare in the SAL. Is that impeachable? That he has accounts with opportunity to present witnesses to support that. He is the Chief Justice of the country, Your Honor. And out of respect, we should at least give him some consideration whatsoever, irrespective of the nature thereof. Now, you're castigating the defense for presenting witnesses that like this and like that. We have presented only 5 witnesses, Your Honor. And they are very, very important to our defense, Your Honor. We cannot be bulldozed into presenting this witness because you like him to testify. That is not the order of trial. That is not the demand of justice, Your Honor. We had been a practitioner, we had been a member of the bench, we have been a member of the Supreme Court. There is no authority nor any jurisprudence that give the reason for compelling a party accused for appearing in court if he does not appear to be in a position to do so, Your Honor. Now, there were several witnesses, Your Honor, today scheduled for trial. Luckily or unluckily, we have a division of labor among the members of the panel, Your Honor. And these were the matters to be discussed by these witnesses, together with the identity, are delineated in that conference. Now, accidentally enough, we never anticipated that those assigned to them will not be able to perform as expected of them, Your Honor. But they are not dilatory in character. For instance, the witness whom Attorney Lichauco will present, he will testify. He will be made to testify that actually the market was pushed through. There was a market operating. All these proceedings were undertaken, and this certainly will cause doubt on the rather clearance or enlightenment on the part of the court that the transaction is a genuine one. It is true. There are check payments, Your Honor, that we utilize the same to cover up the expenditures and the acquisition made by the Chief Justice. But we do not know how much amount of evidence will be necessary to be able to convince the Honorable Court. Kung sa Tagalog po, parang nananalakab kami sa linaw eh. Rules of evidence. Sinasabi ninyo, hindi proof beyond reasonable doubt. Convincing laban. Alright. Ano nga po yung, meron kaming objection, ganito. Now, we have other witnesses, Your Honor. We cause them to be subpoenaed. But we were informed only lately that they will not be able to testify. There is a comment here made. Hindi naman ninyo inilagay ang purpose, kaya nyo tinatawag si Secretary de Lima. My question is there any rule under the revised rules of court which state that in a motion for the request of the issuance of a subpoena, the purpose must be stated? I am not aware of any rule.
We have already ruled upon that, Counsel. We shall not prolong this discussion. Well, I hope you also give due consideration to this court.
Yes, Your Honor, we are.
But you cannot say that we are not giving you due process. You have all the time during the recess to study the defense of your client.
Correct, Your Honor.
To prepare his defense.
And we are very appreciative of that.
To tell you the truth, we are quite disappointed that the witnesses that you brought here this afternoon are people who are testifying about the collection of fees. What has that got to do with the impeachment? To identify records. What has that got to do with the impeachment trial? The question here, and I think you know, because you're an experienced lawyer, is Section 3, Section Articles of Impeachment number 2. And that's why we feel a little disappointed. Now, don't tell us and lecture to us about due process. We're equally aware of our obligation to extend due process to anybody coming before this court. Is it your position that there is no prima facie case presented before this court?
In our evaluation, yes.
No, I'm asking you a question.
Yes, Your Honor.
If that's your position.
In our evaluation,
then that's your problem, if that's your position. I will be frank with you. If you think that there is no case presented here in this court, then that's your problem.
They always, may I continue, Your Honor?
We are all lawyers, trained in the art. And I think we respect your skills and your ability to appreciate the evidence, but equally, we expect you to respect our ability to appreciate the evidence presented to us. The gentleman from San Juan.
Mr. President, I take note of the statement of the Chief Defense Counsel that I was admonishing the Defense Counsel. Mr. Counsel, I am not admonishing you. That was just my humble recommendation to let the Chief Justice appear before the impeachment court. Dahil sa pagkakaalam ko, paniwala ko, pag humarap dyan si Chief Justice, ang bayan magiging masaya, ang impeachment court magiging masaya, at gusto talaga namin malaman kung ano talaga ang buong katotohanan. And in fact, I am not castigating you. I am just merely voicing the sentiments of my colleagues here, Senator Judges. Yun lang po, Mr. President.
Thank you. Thank you very much, Mr. Senator.
Mr. President, Your Honor.
I would like to make it of record that based on our record, the defense has already submitted 17 witnesses. VL, clerk of court, 7, and ex officio sheriff, Attorney Eulalio Diaz III, Administration LRA, Lito Atienza, Attorney VC Cadangan, Noel Quintanar, and the others. That's a matter of record.
Yeah, we did so, Your Honor, for definite purpose, and we
So that's
stated in
why-
the offer, Your Honor.
How many more witnesses do we have to expect? We're willing to accommodate you. Present all the witnesses you want.
We only intend...
That's why we already to give you the due process that you are asking us, and we will give you due process. Fair trial. I guarantee that you will have a fair trial. We denied the motion to quash the subpoena of the Secretary of the Department of Justice. For your sake, if you want to present her again.
Thank you, Your Honor. But we received information that Secretary De Lima sent in an emissary this afternoon. We met him, and he informed us that she will be available only next week, Your Honor. That's why we were
Precisely,
kami, Your Honor.
Because I will tell you, this court will exercise its coercive power to compel the attendance of witnesses for the respondent, to show you that we're ready to give him a fair trial and due process, not only substantive but procedural due process. But we expected that we will be at least given some consideration in not hearing illusory witnesses being presented here to testify on the collection of fees, authentication of documents. There were no more issues about the transaction in the case of the property sold by the City of Manila, including the consideration. Anyway, you want a continuance?
Well, frankly speaking, Your Honor, we cannot proceed now because
All right.
our witnesses are not available,
All right.
Your Honor.
Majority Floor Leader.
Yes, Mr. President, may we ask the Sergeant at Arms to make an
But
announcement?
before that, Mr. President, may we be allowed to
Okay,
reiterate our
we
request?
withdraw, Mr. President.
Your Honor, may we just reiterate our request for the defense to name the witnesses at least for tomorrow?
We have
The
requested
5 or 6 witnesses, Your Honor.
we have requested for subpoena to some of them, for all of them. Yeah, they're a matter of record, Your Honor.
What's that?
We are being asked to identify the witnesses that we will present, Your Honor. We said we have requested for the issuance of a subpoena
I
to
think
compel
the
their
prosecution
appearance.
should be astute enough to anticipate the witnesses that will be presented by the defense and prepare your cross-examination.
In that case, we submit,
instead
Your
of
Honor.
rambling.
We submit, Your Honor.
Mr. President, may we ask the Sergeant at Arms to make an announcement?
Thank you, Your Honor. Before we close.
Please all rise. All persons are commanded to remain in their places until the Senate President and the senators have left the session hall.
Majority Floor Leader. I move that we adjourn until 2 o'clock in the afternoon of Tuesday, May 8, 2012.
Any objection? The motion of the Majority Floor Leader is approved.
Ayan mga kapuso, bago po tayo magpaalam, huling tanong na lang po kay Dean Pangalangan. Ano pong masasabi niyo sa naging takbo ng paglilitis sa araw na ito?
Well, nakita natin na kayang pabilisin ng Senado yung trial kung gusto nila. At yung huling debate, pinag-usapan nila kung yung concern naman ng depensa about fairness and due process, and they were assured by the Senate President that they will be able to expedite proceedings and still respect the right of the accused, of the Chief Justice.
Bakit ganito yung naging sentiment ni
Mukhang napanood tayo ni Senator Jinggoy.
ni Defense Lead Counsel Serafin Cuevas? Bakit was he justified in feeling this way na feeling niya siguro na ma-marginalize sila?
Well, I think ang interpretation niya sa sinabi ni Senator Estrada na dapat mag-testify si Chief Justice Corona, ang tawag niya ay admonition daw. He was admonished. An admonition technically is a punishment in administrative law. Na parang sinasabihan,
parang sinesermonan niya.
Parang sinesermonan. So he reacted strongly na that the accused is entitled to invoke his right against self-incrimination. It was upheld anyway already by the Senate earlier. And as Senator Estrada explained earlier, it wasn't an admonition, it was a suggestion. Kasi nga naman, kung ano ba naman ang goal ng depensa kung hindi kumbinsihin yung mga senador? Sila yung maghuhwes dito, sila maghuhusga. Ang inaabangan ng maghuhusga yung testimony noong
yung basic accusation,
yes.
no?
At napaka-basic ng mga tanong nila. So, ang sinasabi ni Senator Estrada, if you really want to convince us, you better present the Chief Justice. But Vicky, what really I found most telling was the exchange between Enrile and Cuevas.
Yes.
Enrile asked, "Is it your opinion that there is like no prima facie case here?" And then when Cuevas said, "Yes, they haven't made the case," and Enrile said, "Well, then you have a problem."
Yes.
For me, he's virtually saying that, well, we think differently. Kami yung judge dito. And we all are already, well...
We think there's a case.
Yes, we think there's a case. The prosecution made its case. And at this stage of the game, after 17 witnesses, my sense is that their feeling is that the prosecution made its case, and after 17 witnesses, hindi pa nabubuwag nung depensa.
Yung prosecution.
You think that's what he's trying to say here?
Well, that is how I read it. You see, well, of course, we're going into jargon here and the biggest debates about proof beyond reasonable doubt, ganon, or is it merely substantial evidence? Pero sa akin, the goal there is to cast enough doubt, di ba? To cast enough doubt in the minds of the judges so that they will acquit. And apparently, Enrile is saying after 17 witnesses for the defense, they have not cast enough doubt.
Doon sa pinisitang mga ebidensya ng prosecution.
Yes, prosecution. The prosecution made its case, and the defense so far has not undermined that case.
Kasi ang contention ng defense dito is, wala naman kami nakikitang impeachable offense dito. Wala pa namang nagagawang kaso. Which is why hindi namin pinapaharap si Chief Justice Corona dahil wala naman kaming nakikitang impeachable offense.
Yes. In fact, tatlo na lang natitirang impeachable offenses. By process of elimination, yung charge na the Chief Justice led the court to allow GMA to
leave the country.
Yeah, to leave the country. The main witness there was Secretary De Lima, but a lot of her testimony was stricken off for being hearsay.
Based on the
yes, based on the
decision ni
yes,
Sereno.
the dissenting opinion. And it was a mere dissenting opinion. So, we can count that out. Yung pangalawa naman, yung the flip-flopping of the Supreme Court, kahit yun, nabawasan yung charge. Yung Philippine Airlines nawala, yung allegations on the Philippine Airlines case. So, on that
Kasi collegial
impeachment charge,
decision siya.
Yes, it's collegial decision, wala na yun. So, kaisa-isa na lang titira yung SALN.
Yung SALN
na lang.
Article 2 of the Articles of Impeachment. Natanggal na dyan yung charge on ill-gotten wealth. We are left just with the statement of assets
And liabilities.
and liabilities.
Yun na lang, ano?
Yes. But yun na nga eh, despite that, and RILA says, if you think there is no case against your client, that's unfortunate. You have a problem. So parang kahit sa naiisa na lang na article of impeachment na naiiwan based on a real statement, there is a case against the chief.
Based dun sa pagtayo ni Senator Jinggoy, I don't think na ito'y sarili niyang opinion kasi dinadrag niya yung ibang senator na parehas sila ng sentimiento. Mape-pressure ba ngayon ng defense na mag-iba sila ng estratehiya at just to save face na lang talaga to clear his name, personal lang dumalo dun si Chief Justice Corona? Kasi iba na yung direksyon nung huli, di ba? Ng mga senator judge?
Yes. I think so. Patong-patong na yan eh.
Chief Justice, kayo na lang po talaga.
Nag-file na sa ombudsman. And then, and also his public statement, the one you quoted in your program. Sabi niya, you know,
in due time.
Yeah, in due time, papaliwanag ko ito. At ngayon, exactly as you say, galing na ito kay Senator Estrada speaking as together with his colleagues na yun ang inaabangan nila. I think the pressure will be there. You saw the reaction naman of Cuevas. So I will take it that internally among the defense counsels,
mag-iisip na sila.
Justice Cuevas is taking the hard line. Siya yung, there is a right against self-incrimination.
Hindi kailangan ipaharap yan.
Yeah,
no need.
Nobody in this country that can order you to testify. Do not testify. I take it that is his position. Maybe one lesson we can learn is that's parallel to the position of Estelito Mendoza during the opening of the second envelope. As a matter of law, it shouldn't be opened, and he objected, and it was upheld, but it was upheld legally by the Senate, and it was in effect overruled at EDSA 2.
Ito rin envelope din to, di ba, yung bank accounts?
Yeah, maybe yun ang lesson na dapat na maalala nila. Because I imagine Justice Cuevas, I imagine as a traditional litigator, will maintain that there is a right against self-incrimination. Do not appear.
Lumiliit na ho ba ang mundo ni CJ Corona with this development, Dean?
Well, I'm sure it doesn't. The statement of Senator Jinggoy Estrada, I think should be a message. Should be a message to him. Let me put it that way.
And no one stood after him to counter and say, no, we're of the position that he doesn't really have to testify. No, parang in other words, they were basically supporting the stance of Senator Jinggoy Estrada.
You see, Senator Estrada packaged it well. It wasn't really an admonition. It wasn't an instruction. It was just a payo. It was a
practical
question. But he sort of spoke for everyone and said that I'm speaking on behalf of my colleagues in the Senate.
But I think he packaged it gently enough. I imagine if it was a bit more stern and categorical, baka naman may tumindig na mag-dissociate, para bang, or to qualify.
Yes.
To say, suggestion lang ko.
So, yes.
But I think he said it diplomatically enough.
How about Justice Secretary Laila de Lima? Diba, medyo matagal ang iniukol na panahon dito sa pag-counter sana. Gusto nila ipabawi itong sapina sa kanya. Is there any new development that they could possibly talk about on the part of the defense?
Next week daw, available.
What do you think will be their battle plan
Well,
here?
in fact, that was the objection of the prosecution. What they were saying was, ano pa pwede niyong bagong itanong? Tinanong na natin lahat. Nag-testify na. There's nothing more that you can extract. But
meron bang bagong development na nangyari between that time and today na that they could possibly bring up?
I can't imagine, unless they have some secret thing that they can raise. But right now, I cannot imagine any new thing that can be elicited in a new testimony from the Secretary.
Well, next week na siya.
Maraming salamat sa ating legal expert na nakasama natin ngayong si dating UP College of Law, Dean Raul Pangalangan.
Thank you very much, sir.
Salamat po. Yan po ang pinakasariwang balita kaugnay sa impeachment trial ni Chief Justice Renato Corona.
Huwag po kayong bibitiw sa patuloy na pagtutok ng GMA News TV sa paglilitis ng punong maestrado ng Korte Suprema. Maaari po kayong bumisita sa pinakakomprehensibong timeline ng impeachment trial sa internet. Yan po ang www.gmaNetwork.com/news/CJ Trial. Ako po si Vicky Morales.
Ako naman, Arnold Glovio. Ito ang Chief Justice on Trial.
Ang susunod na programa